what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
Hey everybody, how we doing? It is me, Legal Vices, and we are here at the beginning of another week, another day, another week of the Zachariah Anderson trial. And we all know what that means.
As you can see, we've had our eye on you for some time now, Mr. Anderson. Mr. Anderson. Oh, Mr. Anderson. 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 Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson. All right, we got that out of our system. That's good. Hi, I'm Lorax. I'm Brazen. And we are here, as I said, for week 4 of this 2-week trial. Oh, wow. Chaos Coordinator coming in strong right out of the gate with a super chat. Mr. Men's Anderson Diarrhea. You just never know what's coming down the super chat pike, do you? Thanks, Chaos Coordinator. Fondin, wow, thank you so much for your super chat. Let's get Lorax at 36,000. Then maybe he'll get us some merch. Oh well, now okay. First of all, the trial is starting a bit late today. Starting in about 15 minutes later. The judge said he wanted the jury to show up at 9:15. And he hoped to start trial immediately. I can't remember why they decided to start 15 minutes late. I really honestly. Oh yeah, he had to do something. He had to do something in family court for like 10 minutes. So that's why he said it'll take me about 10 minutes. So be here at 9:15, and then we'll start with that. Been there, done that. Says he liked the new camera. It's not a new camera. I just engaged the software. The background blur. So, you know, it's kind of that. The dogs aren't in the room, so there's no reason to distract, and then we can just focus on my lovely face here. So let's do the housekeeping stuff, and then we'll get into kind of a very short recap of what happened. We're waiting for the arrival of our guest, Chandler Remington, who's been here from day one. Bless her soul. Not bless her heart, because that's offensive. Bless her soul, because she's a good person. She's keeping us company. Aussie will be joining us as always, if and when he wakes up. And there's a couple of other people that may be joining us throughout the night, depending on how things go. And all righty. Why did this thing just popped up and told me I'm live? Yeah, I know I'm live. I turned it on. Jacob's proud madre. How you doing? Hello, Legal Vices, and hello to the wonderful chat. I'm lurking, but always supporting. Thank you so much. I just want to say thank you to the mods here that stick with me through this thing here, through thick and thin. You stuck with me through our Maritime Monday stream. We just did a few minutes ago. We spent a good hour and a half talking about freezing to death and cannibalism and fake wolf meat. Yeah, you should have really stayed up on Friday. I know. I've seen it. I've watched all the Friday stuff. Trust me. I was busy banning people in my sleep, apparently. I had my phone next to my head going to sleep. And apparently at some point I rolled over on it and I was timing people out in chat. Sorry about that, guys. I was blocking people in AussieOverlawd's stream. I thought that was pretty funny when I woke up to the mountains and mountains of messages telling me to cut it out. That was kind of funny. But that was just my misadventure. Again, quick housekeeping here. We have currently 1,124 of you waiting for the trial to start. Trial will start in about 15 minutes. Well, it's supposed to start in 8 minutes, but we know the judge. Judge kind of tends to start a little bit late. We'll get there as soon as we can. And Chandler said she will be here in about 20 minutes, 25 minutes at the bottom of the hour. So that'll be great. Chandler is incoming. And let's see, we've got our like and subscribe poll up, our lame like and subscribe poll, which we just put up every day to remind you to hit the like button and subscribe so I don't have to keep talking about it every 5 minutes. We just kind of do it once an hour just to keep it fresh in people's heads. Because even me, I watch amazing amounts of videos every day, and even people that are good friends like AussieOverlawd and whatnot, I still have to be reminded to like other people's stuff. So that's why we do the like and subscribe poll, just to remind you without me having to remind. Today's poll is, did you hit the like and subscribe buttons? Yes. It's kind of a basic answer. Oops, I did now you mentioned it. Yes, let's get to 36,000 subs. And yes, like Schroeder hits it. Oh, I spelled it wrong. Dang it, there's a typo there. Yes, like Schrader hits his oranges. Because if you remember, he was really excited to find a rogue orange in his man bag or his robe, wherever he pulled that thing from. Excuse me while I cough here. I'm back. All right, that's the like and subscribe poll. It's just there for fun, just there for giggles to remind you to do that. And please hit the like button, hit the subscribe button, and I'm on my quest to get to 36,000 subscribers today. I want this to happen today because right now we are sitting at 35,821. Need 179 of you. There's 1,244 of you. And usually, according to my matrix and my matrix, Mr. Anderson, according to my metrics and statistics, we get about 700 new viewers a day. So if even 1/7 of the new people, see, I can't do math. If even 1/3 or however the hell many, if 180 of you subscribe, then we'll have this all in the bag. Lawyers can't do math, particularly not math on the fly. Someone will have the numbers. But anyway, there's more than enough of you here every day that are new viewers to put me over that 36,000 mark. This is what we do here. We are who we are. We're unbreaded. We're based. We are definitely not law and cuck. We are independent thinking people. We do not follow the true crime keyboard warrior wine mom philosophies. We look at the evidence that's presented. The evidence and only the evidence that's presented in court to make decisions on how we would view it if we were a juror. We would never guess. We would never undertake to even conceive about the merest possibility of attempting to guess what the actual jury will actually do in this case, because who the hell knows? I just kind of know what I would do if I was in that situation. And we like to keep an open mind, look at the evidence, how it's presented, and make our decisions based on the evidence. Thank you to Spud Gun, who says it's roughly 26% rounded up. Thanks. Math. All right. Mods, again, thank you for being here. Thank you for all the new viewers. Thank you for all the return viewers. What are we up to now? 1,305 with 700 likes. You guys are awesome. Seriously. I'm glad that you're here. Glad that you're pushing through this with me. Hopefully this will be the last week. Hopefully we'll have a verdict by the end of the week and we can figure out what to do next. All right. I guess that kind of brings us up to where we need to be to begin our little explanation. Oh, yeah, the super chats. During the trial, we'll read the super chats now, but as they come in, but during the trial, super chats we'll flash them up on the screen to let you know that they are received and whatnot. And then during lulls in the questioning or breaks or lunchtime, then we'll power through and read the ones that we'll actually read them. And at the noon break, we'll switch over to AussieOverlawd's channel. So he'll take the afternoon session, as we always do. Right now, the super chats we've got lined up here are the Lonely Kakapo. Thank you for the New Zealand $22. Greetings, everyone. Yesterday, well, that would be Friday. Yesterday, the defense submitted a clip of Gravely mouthing, "Die, die, die" to the snitch, but they didn't play it for the jury. Will the judge let them play it when Gravely is on the stand? Oh, I hope he's on the stand. That would be so awesome if Gravely was on the stand. And that's a little bit of the background information, too, that we were going to talk about. That was the first big fireworks of the day on Friday, was this finally getting to show the judge that Gravely was mouthing this die, die, die right along with the prison house snitch. He denied it. He was like, no, I mouthed it afterwards. You know, I just followed him. We didn't do it simultaneously. And then like, no, we've got the video. We can bring that video in. And then he said, well, no, see, I only repeated it twice. He said it once, and then I mouthed it together with the second and third one. I only said it twice, so it clearly wasn't mouthing it. And even then the judge said, all right. And they had a little delay in the audio. I guess it was going through through Wi-Fi or something, or Bluetooth through the court speakers. And they said, no, just listen to it on the laptop without the audio delay as it works its way through the sound system. And so the judge used his laptop and said, yeah, it pretty much looks simultaneously. And what happened was you didn't start talking after the first, only started talking during the second die. You did the first die and the second die with him, and then the camera cut away before you said the third die with the witness. And then the judge said, you know what? I think I'll just keep this little, I'll keep this little thumb drive. So he didn't let him play the video for the jurors. But that's not out of the woods yet. It could still be played at some point. We're not done with the defense's case. There may be a way to get that in. It depends what issues come up. But the second part of this, will let them play when Gravely is on the stand? Now, Gravely, the district attorney himself, is listed as a witness in the defense's case. That's because he did something really, really stupid. He inserted himself into the case with the witness that was early on. She was a court clerk for, I believe it was Milwaukee court somewhere. And she was supposed to meet the missing, presumed dead victim, alleged victim in this case. She was supposed to meet him the day he disappeared. And apparently she said she went to the wrong house. And stupidly, the district attorney said, well, why don't you take me to that house? Why don't you take me to the house where you were supposed to be? And in doing so, he made himself a witness. And the defense put him on their witness list. So there is a chance. I don't think it's likely. I think they just did it to screw with him. There is a chance that the district attorney could be called as a witness in the defense's case in chief. I think it would be funny as hell if they did. And I would love to see. Yeah, it wasn't a Tinder date. It was a Facebook dating app date. It was even worse than Tinder. So that's what's coming up, right? We don't know if it'll get in, and I certainly, that would be so funny if the district attorney got in as a witness for the defense. I would love that so much. All right. John Schmidt, thank you so much for your super chat. Getting into the mustache game, what products do you use? Waxes, balms, etc. I just kind of use new and different things. Whatever happens to be new. I like to try new things. Boss Man brand products is the main one I use, but again, I'm always looking for new things. Someone made a recommendation in a couple of days ago and sent it to me by Twitter, and I can't for the life of me find out what it was. I'm probably going to try manscaping stuff next, the manscaping beard things. But yeah, just whatever you can get your hands on. Make sure it's specific. Don't use like hair mousse or things like that. Make sure it's specifically for mustaches and beards. It's the end of the day here, so mine has lost some of its shaping. It's you kind of got to work on it a bit there. Thank you so much for that super chat. Samuel Reynolds, afternoon, Jeff. Hope defense does great today. It's going to be fun. I think I'm going to get lucky and there's going to be some fireworks this morning. That would be good. Gigi Beauchamp, right? Hope streams like this help potential jurors. I do too. I mean, I hope to God they don't look at places like Law and Crime and see how the chat behaves there. It's disgusting. It literally disgusts disgusts me, the absolute bias and stupidity that runs rampant in that chat. But hey, thanks, Lon Cuck, for letting me reuse your stream. I just hate your chat. And most of your presentation, your presenters as well. Can gravely object if he's on the witness stand. Nope. That would be for the prosecution to do. The people that's not on the stand. Jacob's proud moderator. Hello, Vices and hello. I already read this a bit. Hey, whatever. I'm lurking, but always supporting. You're so awesome. I'll give you a twofer. Okay, Gravely is called to the stand during the swearing in. As he says, I do, lightning reduces him to a pile of smoking ash. He may just make a point of not saying, well, so help me God. They don't say that in this particular courtroom, but it'd be funny if you did, and that's what happened. This trial has plenty of lulls. It does have plenty of lulls, but it's also pretty damn disgusting and disappointing how the people act. I mean, it's too early to say that word. How slimy the district attorney's being and the prosecution in general, but yet everybody's coming down hard on the defense, on law and crime, telling them that they're horrible, they're biased, they don't know what they're doing. When I think they're doing a fantastic job of representing their client in exactly the way I hope that I would be represented if I was ever falsely accused of something, because I would never do something intentionally. Stingy, how about that pizza box search tweet I sent? Yeah, that was for those of you that were watching. There was this pizza box that they couldn't identify the prosecution's witnesses from the detectives from the police department. They couldn't find out where this pizza box was delivered from because it didn't have any store name on the pizza box, which is weird. But Stingy and others, they found it very, very quickly by just searching pizza stores in Kenosha or where the hell this was, and seemed to find it pretty easily. So it was kind of a stupid thing for the prosecution to say and do. Kyle Cowden, honest for Amish stash product, honest Amish for okay. All righty, let me make a note of this. I have never heard of honest Amish, but now I have. So I will furiously type this into my phone. Honest Amish. Like I said, I'm always looking for a better product. And that's one that we'll throw my hat into the ring with that one and see what happens. And $20 super sticker from Team YouTube. I wish it was the real Team YouTube, then I could say bad things. But I'm going to say great things to Team YouTube because that is so awesome of you to say you are amazing with this blue pear thing. That I've always assumed it's a pear, and I hope it's a pear because I've always called it a pear. Thank you so much for that. Now, the next thing we want to get to about the trial from last Friday, the second big bombshell that happened, was they brought in the anti-snitch. They brought in the anti-snitch. And who is the anti-snitch? It's a person that was in the same cell block as the snitch. They were on different levels, but they were in the same area. They were one of only a few federal detainees in the facility. So I guess they kind of bonded over that. But they brought this guy in. They brought this guy in to testify about what a lying piece of garbage the other prison snitch is. And I think we can watch a little bit of that before the law and crime and court TV feeds begin. Because I thought there were some interesting things there that I wanted to comment on. And if it looks like it's going to be coming up live, then we'll stop that and I'll just spit out what I wanted to say. But right now, this is the beginning of the anti-snitch, the person who's snitching on the snitch for snitching. And he also snitches on the DA, which was awesome. All righty. Let's get on with this thing here. We're all embiggened and ready to go. Plus, this will give me time to calibrate them.
Okay. Would you raise your right hand, please?
This is the anti-prison
Did
snitch.
you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Of course, because why would a prisoner lie? Ever.
Would you state your full name and spell your first and last names for the record, please?
My name is Niklas Ryan McAtee, NICHOLASMCATEE.
Mr. McAtee, you appear to be in custody,
Yes, I am.
and I'm going to approach Judge.
Go ahead.
Yeah, see, now the district attorney is going to object here because he doesn't want to hear anything from this guy.
To this exhibit, Judge, why this individual is in custody is irrelevant because there's no cooperation agreement, so this is not relevant. I don't have any difficulty.
See, this is an interesting thing. Now he doesn't want, for some reason, the DA does not want the anti-snitch to say why he's in prison. He says it's irrelevant. It doesn't matter. And then he makes a good point. The defense is questioning this guy, but the prosecution, the district attorney just made a very good point. He gets nothing from doing this. There's no deals on the table. That automatically gives him much more credibility in my eyes than the original prison snitch. Because the original prison snitch was doing it for the hope of having his sentence reduced, which gives him every single motive to lie and make up stuff about the defendant in order to get his sentence reduced. And this is the second time this dude snitched on something. So the DA just made this guy's point that, hey, you know, he doesn't get anything out of it. There's no plea deal on the table. He gets nothing from this.
With being discussed in custody, but it's irrelevant.
My immediate reaction is it doesn't appear relevant.
Okay. I thought the state would be inquiring about it, but if they aren't, then that's fine.
Well, perhaps they will. I don't know.
Okay. Mr. McAtee.
Yes.
So you are in custody at the, well, tell us where you're in custody.
All right. Well, he's going to go through.
I'm in
He's just going to go
custody
through the
at
basics of
Kenosha
why
County
he's in
Detention
jail.
Center.
Okay. And do you have a state case?
No.
You have a federal case.
Yes, I do.
And just, you don't have to get into all the details, but it's, what's the nature of the charge?
Same objection. Why he's in
What
custody.
the objection sustained?
Okay. So
So they, for some reason, the
You
judge won't let him talk about the
are
nature
here
of the
as
charges.
a witness for the defense, right?
Yes.
And had you been, for your testimony, had you been promised any benefits for that testimony? Promised any benefits for that testimony?
God damn it! I was muted, wasn't I? Crap. See, that's what I did. I know. I muted my mic so I could listen to hear how the balance was by listening to my phone, so the microphone wouldn't pick up my phone. And then, of course, I didn't turn the microphone back on when I was done doing it. Okay. Here we go. Here's what I was saying. This is what I like about this guy's testimony, is because he was asked what he's getting in exchange for this. And he has a very, very interesting response. And it's a really, really interesting line of questioning, I think, here. It says a lot. So, all right. Yeah, I'm gonna stop being thorough because it always leads to boomerisms and bad things happening. So let's listen to this particular line of questioning here. Now, I got to be very careful. Keep the microphone on. Bring this screen up. Push play.
By anybody?
Let's go back a little bit. Have you been promised
Testimony,
anything
have
by
you
anybody?
been, promised any benefits for that testimony by anybody?
Yes.
Yes, he has been promised something. Who has he been promised something by, and what has he been promised?
Who?
The prosecution.
Holy shit snacks. The prosecution has talked to him about this and made him a promise.
And
objection. Irrelevant hearsay.
See, he didn't say objection. Well, what he didn't say was objection.
Everything that guy just said is bullshit. Thank you.
He didn't say that. He said objection, irrelevant, hearsay. He didn't say the guy's lying. He just said it's irrelevant what we promised him, or it's hearsay what we promised him.
You say the prosecution, meaning the U.S. government?
No. The state?
The state?
Yes.
So even the judge is like, what? You don't mean this prosecution, right? You mean the federal government that's prosecuting you, right? It's like, no, this guy. This guy, he talked to me and offered me shit.
Mr. Amit,
now the judge is trying to figure it out.
to your knowledge, is there any kind of an agreement of any kind? At any level, state or federal? Okay.
there's no completed agreement. There was discussions.
So the answer, if there is an agreement, there isn't as of this point. Is that what I'm hearing?
That's correct.
Yeah, there's
You
not.
think
been
the
any
facts are
agreement.
otherwise?
No. There's not an agreement of any kind.
Okay. Any dispute as to that being the fact?
As of we sit here today, yes, historically, that's not the
Now,
case.
don't testify.
See, that wasn't the question. The question was, has anyone talked to you and promised you something? Not, was there any agreement in writing? They said, did anybody talk to you about this? Did anybody promise you anything? Different question.
Don't testify. No. You can ask a question.
I will.
I know you won't disappoint.
Thanks for the confidence. Mr. McAtee, the court just spoke with your counsel, Mr. Ahmad. Is that right?
Yes.
So he's here in the courtroom.
Oh, dang it. The court's here. Crap. Hang on.
Witnesses, I wanted to briefly describe one witness that I suggest may be irrelevant and ask the court to
Bump the
consider
volume a
relevance
little bit
before
here.
that person takes the stand, and then we are ready to go. So I want to make a very short argument and then proceed. That witness is Caitlin Ryan. She is the landlord of Rosalio Gutierrez. What's been represented to me off the record is that what is about to be solicited is that Mr. Gutierrez was behind in his rent and faced eviction shortly before, or was going to face eviction shortly after the date of his of this incident. I'm going to suggest to the court that whether you are in good graces with your landlord and face eviction is irrelevant for this case, and so that's the end of my argument.
And this would just be going towards the police's lack of investigation into Mr. Gutierrez's financial situation. That's the extent of it.
That's very, very speculative that checking on the status of his rent would lead to anything the jury could use in deciding on the case. What am I missing?
There's been testimony about Mr. Gutierrez's finances, that his mother assisted in providing him
The audio is good if you talk into the
towards
microphone, but the
bills,
DA
rent,
does not
things of
talk
that
into the
nature.
microphone because he's an idiot.
There's also been testimony that Mr. Gutierrez was behind. I think this came in with Detective Correa, that he was behind. He had several delinquencies on his TransUnion account. And so this is just furthering going that he was in a financial hardship position. which then gives credence to the fact that law enforcement should have looked into people that he owed money to. Like I said, Judge, I don't have anything further about the relevancy of the testimony.
It's the objection is sustained.
Okay.
Okay.
Then there are a couple of developments that occurred as far as witness availability. The defense had intended on calling Detective Anschutz back to the stand to establish prior inconsistencies. We were informed that the detective went out of state and is not available to come testify today. So the state and myself would hopefully be reaching some sort of stipulation as far as it relates to those prior inconsistencies. So I'm hoping to have something drafted up and ready to be read in by this afternoon, something that addresses both
I
what
hate
the
myself.
state and the defense would have wanted.
So that's pretty
that
shady
witness.
that
Also, Officer Morrissey has
they want to
been,
recall one of the
very
defendant, one
ill,
of the state's witnesses
and so there might be a stipulation
about prior
as far as
inconsistent statements,
his
and he goes out of
testimony
state
as well.
suddenly.
So, yeah, just wanted to kind of give the lay of the land to the court.
Conveniently out of state.
Okay. Many weeks ago, my wife set up a medical appointment for tomorrow at 12:45. That at that time,
Sorry, Judge, I can barely hear you.
at that time did not appear it was going to collide with a 2-week case that's in its 4th week. So I didn't see any conflict. It's at 12:45 tomorrow, and so I probably will break about around noon, and we'll be gone for about 2 hours. And we'll start again at 2, just so you know. They're going to lose a little bit of time tomorrow, and it's probably timing is terrible, but that's what's going to happen tomorrow.
2 hours from the appointment, or you'd be back around
No,
2 o'clock?
I don't think it's a long appointment, so
Okay.
I would hope to be back by 2.
Very good.
Leave at 12 and be back at 2.
Thank you.
Okay. Anything else?
Not from the state.
Not from the defense, Judge.
All right, the jury's coming down. While the jury's coming down, we'll hit these super chats here. We'll mute him while he calls them down. Andrew Hansen, would the DA get to cross himself? No, the other DA would do that. The other assistant DA, she would do that. If I were the judge, I'd make him get up on the podium to ask himself questions and then go back to the stand to answer. I've seen people who represent themselves actually do that. It's ridiculous, but yeah. Marshall Brown, thank you so much for your super chat. Since we're snitching, it's been fun listening to this trial with Mr. Starow at work, shipping CNC parts here, there, and everywhere. Would that be Mr. Sig? Would that be Sig? Thanks, Legal Vices. You're welcome. And John Gordon, thank you so much for your super chat. Law and Crime Chat was losing their effing mind over this guy's testimony. I saw Wine Mums reeing at the snitch was more credible than this guy. The snitch was not more credible than this guy. And again, when we get to the break, when we get to the first break, we'll go back to that guy's testimony. But the gist of his testimony, which is why he found it so fascinating, was that when he was asked, did you talk to anybody? Did they promise you anything? He said, yes, the prosecution. What happened was they went to this guy first before they went to the other snitch, before they went to Munch. They went to this guy first and said, we want you to testify against him, because he was also cellmates for a bit with the defendant, with Zachariah Anderson. The defense asked him first. I mean, the prosecution asked him first to snitch. And he thought about it and told them, no, I'm not snitching. So then they went to the guy that agreed to snitch. And so this guy was on the stand to testify that Munch was full of shit that he said he would lie, and if you didn't have anything on someone, you just lie and make it up, and to testify about how the prosecution, how the DA came to him and said that if you'll testify, if you can get something on this guy and testify, we can help your charges. I'll put in a good word for you, kind of thing. Exactly, Ohio Pigeon. They were snitch shopping. That's why he did not say the guy was lying. He just objected on the grounds of hearsay and relevant.
Basketball season is over. Well, I think you are paying close attention.
I thought the NIT tournament was still going.
Well, anyway, we're ready for baseball. And we're ready to continue the case. So, Ms. Muller.
Thank you, Judge. The defense would call Sergeant Daniel Bandy to the stand.
All right, who's Daniel Bandy?
I do solemnly swear that the testimony you're going to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please be seated.
Sergeant.
Good morning, Sergeant. If you could just spell and state your name for Medicourt reporter.
My name is Daniel Bandy, Bandi.
And how are you currently employed?
Ooh.
I'm a sergeant with the City of Kenosha Police Department.
How long have you been in that occupation for?
I have been a police officer for, I think, 28, going on 29 years. I've been with the City of Kenosha for the last 16.
And as a sergeant, how many years have you been employed in that position?
I believe 7.
No, not that one. Go away. This one.
Just jumping right to it, do you remember doing case in do you remember doing work in the investigation of the disappearance of Mr. Rosalio Gutierrez?
I was involved in that case as a supervisor, yes.
And can you explain to the jury what a supervisory role is like in this type of investigation?
Generally, as a supervisor in specific, I'm assigned to the Detective Bureau, and basically I advocate for the detectives if they need supplies or if they need additional personnel, that sort of thing. I also inform our administration what's going on, explain to them the situation, keep them updated. That's my basic role. Occasionally I jump in and we'll talk to people or fill in where detectives might need a hand. In this particular case, what I did is a brief canvass of the apartment complex, talking to other people that were in the complex briefly to see if other detectives needed to go take statements from them or to follow up and speak with people that live there.
I'm thinking we may need to break out a bone steel for this guy.
Of other residents on the property, do you remember who you spoke to?
Oops, sorry.
Specifically,
God dang it.
by name, no, I do not.
Do you
Nice
did you
Pee Wee
speak
Herman
to
blast.
An individual named Jennifer Ziegler?
I believe that I did. It sounds familiar.
How about Nathan Hensley?
I believe so.
In addition to you canvassing individuals who lived at Wood Creek apartment, you also were overseeing other things that were occurring.
Yes, that's correct.
One of which, the drone usage that Kenosha Police Department used to do an aerial search of the area
Drone
west of Mr.
steal.
Gutierrez's apartment.
I requested it that the drone from the Sheriff's Department had the drone program at the time. They still do. I requested that they come out. I was not overseeing the operation of that, though. I'm not a licensed. I don't use that.
And why did you make that request?
The request was made very simply because it's an efficient way to search a large area rather quickly.
And did you ask that any foot searches be done of the surrounding area around Mr. Gutierrez's apartment?
I don't remember. I probably did, but I don't remember if I did. And I don't think I specifically named that in my report.
Private
To
pile.
your knowledge, after the drone was used to conduct the aerial search, was there any information gathered from that that helped in the investigation?
From what I remember about the drone search is that there was nothing found in the area that was searched. So in that respect of nothing being found, that was important.
His name is Bandy, Andy White.
And that was just
Not
the
Bondi.
area west, that wooded area west of Mr. Gutierrez's apartment.
Yes, that's correct.
That there are other wooded areas around that area. To your knowledge, were those searched?
I don't remember.
Do you remember overseeing around May 21st, 2022, the pumping of the septic tank on Mr. Anderson's property?
Yes, I do.
And why did you, as a sergeant and overseeing this investigation, ask that that be done?
That the septic tank was pumped. That is a place that you could hide a body, and the tank had liquid in it, and so we wanted to look and see.
And did you find anything?
We did not.
This guy needs to read audiobooks.
Did you also ask, or did you ask about anything be done as far as the dumpsters on Mr. Anderson's property?
Boy, Hempland TX has gifted 10 Legal Vices memberships. If any of you got those gifted memberships, thank Hempland, Texas.
We ended up, I believe, emptying it out and looking through it.
And why did you want to empty it out and look through it?
See what was in there?
And you didn't find anything?
Nothing of evidentiary value in this case.
When you say evidentiary value, what do you mean by that?
There was trash that was in there, so the broad topic of, is there anything in the dumpster? Yes, there were items in the dumpster, but there was nothing that I remember that was like bloody or, if there was body parts or a gun or drugs or anything that would be illegal or that was pertinent to this case that I remember.
Great. Dumpster diver.
I have nothing further for Sergeant Bandy, subject to redirect.
That was short and to the point.
State.
Sergeant Bandy, you were asked about drone search of a wooded area as well as whether other wooded areas in the sort of general vicinity of Wood Creek Apartments were searched. Since May of 2020, have any human remains been found in any of the wooded areas that would be covered in those questions, which you thought would cause one to need to compare it to Rosalio Gutierrez?
Not that I'm aware of.
Okay, and you would be aware of that, correct? As a sergeant at the Kenosha Police Department, if human remains had been found in any of those areas, you would know that.
That's correct.
And you were asked about the contents of a dumpster at the Anderson, at the Mequon address of the defendant. When you indicated nothing had been found, was any carpet that had been cut out of that minivan on the property, was that found in the dumpster?
I don't believe so.
Okay. And were any clothing found in the dumpster, such as a blue checked plaid shirt or any of those kind of things?
No.
I have no further questions.
Any redirect?
Yes. Yes, thank you briefly. The state had just asked you about whether any remains have popped up in the area surrounding Mr. Gutierrez's apartment since May of 2020. However, since, let's say, May of 2020, have Kenosha Police Department or any law enforcement agencies, to your knowledge, continued to do any active searches for Mr. Gutierrez?
Yes.
And when was that?
Since the original incident, I don't know the exact dates.
So, but nothing this year in 2023?
No.
Not that I remember.
And nothing in late of 2022?
Again, I don't remember the exact dates. It's not in my report, and part of my function is to support the detectives. The detectives do a lot of the actual searching, and so I may or may not accompany them. So, for example, if we were going to go out of county,
this is direct
search at a particular location, I would arrange for resources from that particular county, whether it's a fire department or a police department, whatever it might be. The specific dates, I don't remember.
And that's fine. And I guess what I'm trying to ask is, it's not as if every week there's a search party that goes out.
That would be fair.
And the additional searches that had occurred were closer to the May 19th, 2020 date.
I guess you have to be more specific in searching of where.
Sure. So were you aware of the searches that occurred near Harrington State Park?
Yes, I was.
So that was an additional search that occurred?
Yes, it is.
And that, to your knowledge, did that yield any evidence?
I was not part of, let me back up. I was not physically at that search. And as far as I know, there was no evidentiary value or anything of evidence that was recovered during that search.
Talking about
and then there was the search of the Greenview/Anderson Tree Farm.
Correct.
Whose witness this was. This is not the prosecution's witness. This is the defense's witness.
A subsequent search that was done.
There were searches done at the Anderson Tree Farm. That is correct.
And
this is redirect, not recross.
Yes.
And at the residence of Susan Brown Williamson.
I'm not sure I know who that is. If that's the Cedar Beach Road address, then yes.
But to your knowledge, I guess what I'm going back to is that outside of those searches that were completed by Kenosha Police Department, if you know, there weren't any additional searches that were done in the Kenosha area.
Well, there were searches of like electronics. I don't think that's necessarily what you're asking. As far as the physical searches, I don't remember any. Detectives may have gone out and searched without notifying me. But again, that's a specific question to a specific detective that I can't answer.
Nothing further, Judge.
Nothing on that.
You may step down.
Thank you.
All right. That wrapped that up. Short and to the point. Stephen Cooper, I thought the FBI was the only group who ran drones in Kenosha.
Portier to the stand.
And illegal vices, my name is Brandon. Where is the no, I'm not gay, stop hitting on me, Jeff? No, don't touch me there. This feels funny. No, it hurts. Stop. Help me. Simply. Option for the poll. Yeah, that ain't going to be an option for the poll. Illegal vices, my name is Brandon. Appreciate your super chat, though. But yeah, that will not ever be an option, I believe. And hey, Legal Vices, did you get my Twitter DM? Yes, I did. I got it. And that's it. DA, do the job for the defense again. What a plum. Exactly. It's happening with Harper says, how does no remains help the state? He didn't find anything. Exactly.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? So help you God. Please be seated.
All right. So why was that last guy called?
Officer, if you could be so kind just to state and spell
Another
your name
officer.
for Madam Court Reporter.
Okay, Officer Luke, Luke. Last name is Courtier, Courtier.
And where are you currently employed?
The City of Kenosha Police Department.
And how long have you been employed with the police department?
Approximately 7 years.
Oh, he's got some serious Nick Ricada
In
shoulders.
your term of employment with the Kenosha Police Department, do you remember working on a case involving Mr. Zachariah Anderson?
I do.
And how involved was your involvement in that case?
I had a small part in it. Very small part.
And what was your small part, if you remember?
I was asked by Detective Kennedy to respond to the Kenosha County Jail and retrieve Mr. Anderson's clothing.
Okay.
Mm.
The clothes that you examined, were these the clothes that Mr. Anderson was wearing when he was arrested?
I'm not sure.
Okay. You examined them though, correct?
Correct, yes.
Okay. Judge, I do have exhibits that I would like the officer to open. I was informed that Detective Correa had taken the scissors. I don't know if we have another pair of scissors.
Well, you don't like the other scissors? Something wrong with the scissors? Well, while they're finding scissors, I'll bring in my exhibit number 1, Chandler Remington.
Hello, hello. Good morning.
How are you?
I'm great. How are you?
Good. Your microphone's is really poppy.
Oh, it is?
It is.
Oh, no. Okay. Give me a second.
I'll take extra large. If you have large, it doesn't matter.
Okay, I hope that's a little better.
That's much better.
Good.
Give this guy the scissors with the rounded ends on them. I don't think he can handle sharp scissors. How are you, Miss Remington?
I'm pretty good. I'm so sorry I'm late. I was setting up my microphone, which is apparently terrible. So,
If you don't mind
very
just
good.
opening that that exhibit.
Okay.
Thank you.
Oh, this is like his lunch box he brought home from his. Jeez, he almost cut his finger. He's got to be careful with that middle finger. That's twice he almost cut it. Good heavens. I collected.
Very important.
Remove them.
Yes, please.
I collected a donut and a tuna fish sandwich from my mother. Ooh, and I just collected a text message.
Can you explain what?
I don't know why
that
that's
exhibit
funny,
is?
but it is.
This is a V-cut white T-shirt, size large, with a George brand.
And is that the T-shirt that you had previously inspected?
Yes, it is.
Wow. So every time you get like inspected by
And
14, this is the
When
guy that does it.
When you examined it, did you observe any stains or anything of that nature?
Yes, I did. I noticed a very small stain on the back right side of the shirt. It's like a light orange brown stain right here.
Did you taste it?
Was there anything else that you noticed about the shirt?
Not that I noticed, no. Well, I guess other than the fact that it appeared new.
And it's quite fashionable.
Basing that on the fact that the imprinted tag on the back of the collar is not faded at all.
And do you remember making a observation or determination about the brand of that T-shirt?
I do. I believe it was probably via Google, a Google search revealed that this brand, George, is commonly sold by Walmart stores.
Walmart?
Correct.
And then were there any other things that indicated prior use, such as sweat stains or any other stains that you had?
All right. Insert
noted?
semen jokes
Not
here.
that I noted at the time.
How about now? Do there appear to be any, what appears to be sweat stains?
Yeah, there looks like there's like some yellowing on the bottom of the armpit area. That would be common with sweat stains.
You can put that exhibit back in the bag. Thank you, officer.
So this guy's whole role in this case was to look at a T-shirt and put it in a bag, apparently.
Is he more important or less important than that guy that threw the phone around the room in the Murdoch case?
going to hand you what's been marked as Defense Exhibit 300, and I'd ask that you do the same with opening it. Yeah.
Oh, they're trading lunches. All right, we have sounds of silence there for just a quick second while he re-gloves. And Kyle Cowden said, what a great name, Chandler. Pretty too. Hashtag.
Oh, thank
not.
you, Kyle. That's very sweet. I appreciate it. I like my name a lot. And that's a lovely compliment.
Almost there.
Oh, and speaking of Rittenhouse, in case you're wondering, Natalie Wisco is in court today and tomorrow and Wednesday, I believe, doing a very important case. She said she will try to get here if this trial is still going by Thursday or Friday, which it very much looks like it will be. Nah, if that was Dunkin' Donuts, he'd open that package a lot faster.
Okay, now are these the jeans that you previously inspected?
Yes, they are.
And when you inspected them, did you make an observation about the brand?
Yes, I did. I noted that it's Levi Strauss Company brand, size 34 wide, 32 long.
And did you make any conclusions or do any further, I guess, investigating into where those jeans can be purchased?
Again, the same way I did the t-shirts, quick Google search revealed that they're commonly sold by Walmart stores.
He needs new gloves because he's a good cop and doesn't want to contaminate evidence like every other cop does that ever gets on the stand. He's a good guy. Conscientious. Here, let me help. Okay. There, now go clean your keyboard, Gavin.
Jeff, you should start an ASMR channel like Cat 10 Barge.
Exhibit 319.
Could be a big hit. Just saying.
Yeah, his daughter said he never testified. He never wears Levi's. Well, clearly that's wrong. And now he's got to touch the skivvies.
Open this one.
Oh God, do I have to open this one? Oh, really? It's like, sweet Jesus, please let it be his socks. Please let it be his socks. Oh, it's just flip-flops. He did testify he always wore flip-flops or thongs or whatever you want to call them.
About those flip-flops.
So these are the flip-flops that I examined during that day. Some of the things that I noticed, I'll say in addition to the colors, was that they appeared very worn, just based on the fact that there's the foot impressions. You can make out each individual toe. So they appear to be frequently worn. The other thing that I noted was the two different sizes. This is the shoe here.
Okay.
Noted that it's size 11, and then the left shoe is size 12.
And did you notice anything about the brand?
I did, just based on the logo of it. I don't think it had a actually written brand name, but I did a Google search describing the logo that I observed, and it showed me a Google image photo of that same logo.
And did that search yield any information about where those flip-flops could have been purchased from?
I don't recall on that one.
Probably
If I were to
Walmart.
show you a copy of your report, would that help refresh your recollection?
Yes.
All right. While they're looking at his report, Rick Nikita says, "Prove to me that Chandler isn't an Aldari Harlequin, and I'm not stuck inside of a holodeck." Star Trek.
So it's
You might be in a holodeck.
yep. Okay. So
You'd never know. You might be part of the program.
That's a very good point.
yeah, yes.
Okay, and where was that?
So it's Athletic Works at Walmart.
And you said that they appear to be heavily worn.
Yes.
Now, when you're inspecting these items, the jeans, the shirt, these flip-flops, why were you inspecting them?
I'm an evidence technician for the Kenosha Police Department. So anytime that I'm taking, I was assuming that this was evidence in a case. Just taking note of anything that could be noteworthy of anything on the shoes or the clothing. So I could be descriptive in the reports. I didn't know if Detective Kennedy, who was the one that asked me to retrieve the clothing, had seen these for himself or if he's inspected them. So I needed to be able to describe what I saw so that when he reviews my reports, he would know what I saw on the items.
And you could put those back in the bag, and I'll grab them from you in a bit.
What's in the
One thing that
bag?
you're
What's
looking
in the
for,
fucking bag?
Evidence of blood stains, other stains, things of that nature.
Correct.
And did you observe any sort of those type of stains on these flip-flops?
Nothing that I would be able to say that was.
And the same question as it relates to the jeans. Were there any stains that you thought were important to know?
On the jeans, no.
And then the shirt was just the orange stain on the back.
Correct.
And the yellowish stains near the armpits that you see now.
Correct.
Ew.
Do you remember also inspecting a pair of underwear?
Yes.
Yeah, don't show that,
And
please.
do you remember any of the
We have to
details
see that.
regarding the underwear?
Yes, I do. I remember comparing to the other items of clothing, they appeared very worn or heavily used due to the elastic in the waist area was very stretched out. And then I also remember them being Fruit of the Loom brand.
And did you make a determination about any stores that commonly sell that brand of underwear?
Walmart, once again.
Walmart? And so could be a question I don't want the answer to, but were there any stains of interest on the underwear?
Say no. Say
Not that
no.
I noticed. Not that I recall.
And now when you
Define
had
stain of
retrieved
interest.
these items, they were in evidence similar to how they are today?
When I retrieved them from the jail?
Yeah.
No.
Okay. How were they when you retrieved them from the jail?
So at the jail, whenever you bring in an inmate in, all their items, belongings get placed in like a big blue, it's almost like a mesh style bag. That's what I retrieved them from.
And he knows
And
all
I
about
placed
mesh
them in
type
paper
bags.
So you were, to your knowledge, were you the first person that did any sort of evidentiary investigation or looking on these items of clothing?
It'd be assumed that, yes.
And so kind of the chain of that custody was, correct me if I'm wrong, but was Mr. Anderson gets booked into the jail, his clothings get put into that blue mesh bag, and then you took them to inspect them.
Correct.
And then after you inspected them and reviewed them, how did you process the evidence from there?
So I'll start from the beginning. So I go to the jail. They hand me this blue mesh bag. I put gloves on my hand, on both hands, placed the items into bags, transported them to the Kenosha Police Department's Evidence Bureau, where we process all our evidence. Typically, you would line, there's like a large metal table in there for our workstation. Typically, we would line it with a roll of like brown paper. I remember that day we were out of that paper, so I obtained several paper bags, which fits the same purpose, and line the table with those instead, just to prevent any cross-contamination of any evidence from other cases. And then again, using gloved hands is when each item I started photographing and inspecting.
And then did you eventually at the end put them in paper bags and seal them?
Yes, I did.
Similar to the paper bags we see today?
Correct.
And so just generally, the items that you observed today appear as they did when you inspected them back in May of 2020?
Yes.
I have no further questions for this witness.
Okay.
Thank
you. So, officer, we talked a little bit about obviously all the clothing, the underwear specifically. Those were actually found in the front right pocket of the jeans. Is that accurate?
I don't recall.
Would your report refresh your recollection?
Yes.
Showing you a document and pointing to the paragraph of what I believe to be relevance. Can you read that to yourself, please?
How am I looking at
Does that
you?
refresh your recollection of where the underwear were found?
Yes.
And where were those underwear found?
The right front pocket of the jeans.
And the brand of those underwear were Fruit of the Loom?
Correct.
Now, the jeans
Ashton
themselves,
answered.
in your report, did you indicate that they did not appear to be heavily worn and were possibly even new?
Yes, I did.
And did you make that determination based on the general look of them and the fact that the Levi Strauss tag on the back wasn't faded at all?
Yes.
And then with the white V-cut short sleeve shirt, you also indicated in your report that it appeared to be very new as the imprinted tag on the back of the collar was not faded at all?
Correct.
Which obviously was in sharp contrast to the shoes you reviewed, which appeared to be very well worn.
Correct.
The grape guy is the killer.
In the Fruit of the Loom commercials?
Yeah. Yes,
The guy in
that's
the
what we were
grape,
talking about.
the grape costume. How do you know it wasn't the banana? Come on, people.
Nothing
Use your
further
heads.
to say.
I have an incoming.
All right. Now you guys are fast. Well, while they're doing that, this is how, and this came like this came several minutes ago.
Mhm.
That's how fast you guys are.
That's fabulous. I love that. Who did that? That's genius. Great.
That
advertising.
was. I don't know if they want me to spill their beans here from Twitter or not, but yeah, that was good. I like that.
Okay.
And that came in like 10 minutes ago. That's how fast
you
you
think?
guys are. That was funny.
Django, what do you think? Good meme?
All right, let's bring the court back up. All righty.
Okay. No.
And while they just bring the audio up and down again. Illegal Vices, my name is
On
Brandon, says,
two
does size
additional
really
witnesses, they will
matter?
be
Yes, size
here
really
at
matters.
11 and 11:30 respectively. The last two witnesses. The defense would like to take this
The last
time to
two
be able
witnesses?
to converse with Mr. Anderson about his right to testify at this juncture. So
No.
I can't believe I'm hearing this.
What?
There were the issues, Judge, with the two witnesses that we had anticipated going earlier. The one who informed us just yesterday that he's out of state, the officer witness, and then the other witness who appears to have the flu. So that's why our other witnesses aren't going to be here until 11 and 11:30 respectively.
You can't get mad at the defense for this, Judge. It's the prosecution that fucked him over.
Do you have any rebuttal witnesses who are available now? You don't have to.
Yeah, we told our rebuttal witnesses to be available at noon. So I think we do have two brief rebuttal witnesses. I might be able to get them here sooner, but they're not waiting in the hallway.
Well, your witnesses, have you called them and told them to get here sooner?
Yes, we have. One of them is at a doctor's appointment, so he'll be here at 11:30, and then the other one is informed that we're ready to call, but they're traveling from out of.
Do you want me to?
County.
So mine are jail witnesses. I can see if I can get them here sooner. I just can't guarantee it. They were told to come at noon.
Well, I don't want to force you to put your case on earlier than you're required to. If they were, you know, you get them from the jail will be 20 minutes at least. So,
One is a records custodian, so she's probably working right across the street. Should we at least try her?
Please.
Okay, I'll call her. Yeah,
Let's see if we can keep this.
We'll see if we can at least get her here.
We'll make an effort to keep this shorter. But otherwise, you're welcome to have some coffee.
So did I hear that correctly? We only have 2 witnesses left?
That's what it sounds like to me. Wow.
Oh, okay. Interesting.
Unless he testifies. And I can't imagine he would.
I don't see it. I really don't see it.
He can't. This isn't a Rittenhouse thing where he's gonna save the bacon. Again, it's between him and his lawyers, and ultimately up to him. But I can only see it doing harm.
Yes, agreed.
Wow. Huh. We may not. We may be done before Thursday or Friday. Thursday. So if we figure if they finish today, we do all the rebuttal stuff tomorrow. No. Wednesday, you do closing arguments, jury instructions, and start deliberation. We could be done by Thursday.
We could.
Or Wednesday
we could
night.
Be done, yeah. In time for OJ.
All right. Well, gosh, I guess that was just yet another fake. Let me get rid of the box here. Get through some of the super chats here now that we've got like an hour and a half before anything happens again.
Let's do it.
Illegal Vices. My name is Brandon. Was saying, does size really matter? Well, of course it does. As Robin Williams' sex therapist character, Dr. Roof, says, you can't make butter with a toothpick. Size does matter, apparently. Vince Clortho. Come on, man. We all shop at Walmart. And Illegal Vices. My name is Brandon. Again, you first, lawyer man. What's a stain of interest in South Korea, aka the land down under? Yeah, I ain't interested in any stains on any other man's underwear. Or my own for that. I mean, I have. Moving on. Valhalla waits. Legal Vices. I heard some weird statistics on South Korean.
His daughter's
sake.
The communication is that the subpoena has expired, that he's past the time. I don't know what that. I don't have anything to do with their subpoenas. We certainly have not told anybody to leave.
Judge is pissed.
We're going to try to work out a stipulation. Figure out a way to cover this.
Yep. Judge, we're waiting for that photo witness to come. Can I take my client back there to speak with him?
Me?
Thanks.
With the approval of the gendarmes. I feel like I've lost control.
Yeah, which week did you feel that?
Yeah.
We're getting there, Judge. We're not gonna.
Well, I know that, but look at this poor jury.
We're committed to making sure this happens. So,
Wow. Okay. Let's get back a little bit there and see what that was all about.
I heard them say something about the daughter, but I have no idea. Because it kind of cut out.
Perjured manner.
His daughter's vol.
This is somebody, a court clerk or somebody. Maybe I'm not even sure whose witness this. That sounds like the district attorney woman's voice, doesn't it?
I thought it was Nicole Muller, but I could be incorrect.
His daughter's volleyball game.
That sounds like Nicole Muller.
the communication is that the subpoena has expired, that he's past the time. I don't know what that. I don't have anything to do with their subpoenas. We certainly have not told anybody to. But we're going to try to work out a stipulation.
Okay, well that's
All right.
interesting.
No idea what's going on.
Winter Steel said, "How can you not have your witness ready, DA?" Well, this is the defense. Their witness isn't available because he was a witness that was being recalled. One of the prosecution's witnesses was being recalled so that the defense could ask that other witness about prior inconsistent statements. But mysteriously, he just happened to go out of state today and is unavailable. And their other morning witness has the flu. So therefore, they're stuck here in this weird little time lapse. They were asking about the possibility of getting one of the state's rebuttal witnesses in. They're going across the street to see if that's possible. But yeah, this has kind of turned into a shit show here again. I knew it would be a crazy, weird day.
Job. It's been a shit show from like day one.
True.
I mean, it was a shit show starting, last year before we got the mistrial. But I mean, it does get more interesting every day. I will say that.
But see, that's where my objection to the whole thing. My shit shows that happen during the morning session are all crap like this, where it's a shit show because nothing happened. The shit shows in the afternoon that Hayden gets to deal with are these really cool things.
Yeah, it always happens to be when you leave, the interesting stuff happens. I think it was 5 minutes after we both left that all of a sudden they were trying to recall Gravely as a witness. They brought up the mouthing of die, mother, It's before the 2-hour mark. I'm learning. But that was right after we left. And so of course I had like stuff to do at that time. It's just, and then Joe comes in and everything gets interesting. So it's just kind of the law of the land, I guess.
Jonathan Smith asks, is the crime that defendant shops at Walmart? Everybody except Chandler shops at Walmart.
I don't have a Walmart near me. We don't have them. We don't have very many Walmarts in Los Angeles.
You just think you're better than us, don't you?
I just don't have a Walmart to go to. I've never been to Walmart. I've literally never been to Walmart in my entire life. I don't know what it's like.
They used to have a Walmart here. They used to have a couple of Walmarts here in Korea, but they went out of business. Their business model really sucked here. And Dave Edwards, don't reveal his true identity, Iron Man. Okay. And Frenchy Irish is cute cat, Chandler.
Oh, thank you. His name is Django, and for some reason everybody thinks he's really giant, but he's tiny. He's like 8 pounds. And he's very friendly. He's always sitting with me. He's been very snuggly lately. So he wanted to make his debut today, I guess.
Well, he did.
Now he's right here. Hey, buddy.
Oh, wait.
That's the cat that's yelling in the background, by the way.
Wait. Very brief rebuttal witness. Apparently, the court clerk from across the street can testify.
So we might as well take her while she's here, and then, so have them come in.
Apparently, they're retaping the evidence or something. All right, so I guess the clerk from across the street can testify. But before she gets here, we need to burn through a couple of things real quick. Like I said, we've got lots of time during the breaks. We can show stuff from last Friday. Illegal Vices. My name is Brandon. Says objection. Sober. St. Patty's really whooped your butt into a nice hangover and beard trimming. I haven't trimmed my beard in a couple of weeks. Didn't whoop me into a nice hangover. Did pretty good. You just haven't had a reason to have a drink today. Don't have to do that every day, but
You still have all that peanut butter whiskey left, so.
I do. It is literally has not moved since the first little drop of it left the bottle. That is really interesting stuff.
That brand also makes like an apple pie whiskey that I've tried, or it's like an apple pie moonshine. I wouldn't recommend that either. It's pretty terrible.
Yeah. Yeah, and don't forget the landlady who the judge didn't. It was the landlord. Yeah, the judge wouldn't let him. I think it's a him testify, him or her, ma'am or her. It's Pat. Somebody wouldn't let testify. And Vince Clortho, Steve Leno just told them to leave town. Right. And we were asked a little bit earlier by Valhalla Awaits. Legal Vices. I heard some weird statistics on South Korean bathrooms yesterday. Do you have a wet bathroom or a full shower? Almost all. I in 35 years, I've never seen a house with a full enclosed shower. They're all wet baths. And I'm curious to what statistics you saw about South Korean bathrooms. But yeah, they're all wet open baths with like open showers.
What does that mean? I've never heard that term before.
Well, like you don't have an enclosed shower unit. It's like a hose with an adjustable shower head on it, and you shower off before or inside the bathtub. It's kind of usually you fill the bathtub up with water. You shower outside of the bathtub to get yourself nice and clean, and then you soak in the bathtub in nice, fresh, clean water, rather than filling a bathtub full of water and then soaking in dirty water for however long you soak in the bathtub. So now Valhalla Awaits. I'm wondering what the hell statistic you saw and why you saw it. But interesting. Yes, save that for F it Friday. No, that peanut butter whiskey is never being drunk. It might be good for ice cream or for like using it in a chocolate milkshake or something, but it's never just going to be drunk from the glass ever again.
If you sent it to me, I would send it back, or I would throw it in the trash. Unless you really wanted me to drink it.
Old Smoky Apple Pie is great. I'm not a flavored whiskey guy, but Ari Jacob, every time she comes on, especially on F it Friday, she's like liquored up on peanut butter whiskey, and I just saw it in a convenience store, and it was dirt cheap. So curiosity got the best of me. Now I just have to figure out what to do with it.
Like I feel like I've seen peanut butter stout, and that makes sense. I've never tried. I think I tried. I don't know. I can't remember if I've tried one of those.
Illegal Vices. My name is Brandon. Thank you so much for the super chat. What does that liquor taste like? Please do tell. I will tell you while I have a delicious pour of Shackleton whiskey in a Shackleton's glass, because that poison will never darken my lips again unless it's mixed in some sort of cooking product. But I'll tell you what it does taste like. It certainly doesn't taste like Shackleton's. It literally, I mean, like the first 5 seconds that this old smoky, what the hell? There we go. Bring it back into focus. The old smoky peanut butter whiskey. What this tastes like. The first 5 seconds on the palate is really bad. I mean, it's just offensive the first 5 seconds. But then pretty much it just tastes like warm, melted peanut butter. Like really peanut buttery peanut butter. It literally just tastes like you'd put some peanut butter on the stove in like a double boiler and got it nice and melty, and then you just filled your mouth with it. And
no.
And then the finish is just more oily peanut butter with like a little alcohol burn to it. It's really not good.
Yeah, it's been years since I tried that stuff, and it haunts my memory. I can't.
What? And he says, my God, they do they not bathe too often? Oh, Koreans are huge bathhouse culture. I mean, there's saunas. I mean, I can look out my window and probably see 5 different saunas. They have spas. They're very much a water-oriented culture here on the coast. They bath quite a bit. So you can take a quick shower in the morning, but when you want to do panchinok, which they call you, it's like you just cover yourself up just up to the neck in like boiling water. Yeah, you shower off before you get into the bathtub, so you're clean. If you don't soak, you don't actually get the dirty oil out of your skin. All righty. Interesting how we got turned on to a bath conversation here, i.e. rust stains in tidy whities. Yeah, we don't want rust stains in our tidy whities, do we? Vince Clortho, rum versus whiskey on 1600s ships discussed. I'm pretty much sure rum and whiskey in the 1600s tasted like absolute garbage. I'm sure they were all pretty hellaciously bad. Ugh. Let's see. All right, are we going to get this witness here or what? Come on. There's a Korean sauna spa in Dallas. It's amazing. They do have like family saunas and couples saunas, place where you just like go and chill out in the tub together, chill out in the sauna together, do a big spa thing together. The bath culture here is amazing. Brian Miller, you could send me the peanut butter whiskey. I'll drink it. You disappoint me, Brian Miller. Step your game up. I went to one of the spas when I was in Korea. Incredible experience. Absolutely. Try making Rice Krispie bars with it. That would be good if I needed like the 8 million calories in a Rice Krispie bar. I'm trying to go the other way. Illegal vices. My name is Brandon. Sir, into water sports. Tell us more about that. Not me.
You know what you could do with the whiskey? You could make like an ice cream with it.
That's what I was thinking. It'd be like it'd make like a good chocolate. I guess I could like make the ice cream with it too. Yeah, I thought about like pouring it on top or using it in a milkshake, but.
Well, I've made homemade ice creams before, and if you put alcohol into an ice cream, it makes it much more scoopable. Like it doesn't. It prevents ice crystals from forming.
Yeah,
according to my knowledge of ice cream science.
You're absolutely correct.
Ordinarily the defense
I make all of my ice cream.
Its entire case.
All right, here we go.
Before the state is invited to present any rebuttal evidence.
So they're going out of order.
Because of the shortage we had this morning, the district attorney was kind enough to arrange for what he describes as a brief witness to testify at this point. So, Mr. Gravely?
State calls Jill O'Hanlon to the stand.
Jill O'Hanlon, or O'Hamlin. Didn't quite hear what it was. But anyway, yes, you are correct. I make all of my. I love homemade ice cream. Making it with like Bailey's Irish cream is really super good. That's what I think I'll do. I think I'll do that on the weekend. I'll make me some peanut butter whiskey ice cream and let y'all know how it tastes.
Yes. Tell me how it goes.
QRM 30 rum with an aged Cuban cigar is the best.
The testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, Nicholas.
Please be seated.
Ms. O'Hanlon, can you state your first and last name and please spell your last name for the record?
Jill O'Hanlon. It's JILLO''HANLON.
How are you employed?
I'm a detention systems manager for the Kenosha County Sheriff's Department.
What does that mean you do?
An array of things, but basically track the inmates' activities from the time that they're booked to the time that they're released.
Are you the records custodian for records pertaining to where an inmate is located at any given point in the Kenosha County jail system?
I have access to pull those records, yes.
Okay. And did you comply with the request to indicate specifically what cell 2 separate inmates were housed during a time period of February 2nd, 2022 through February 5th, 2022?
I did supply some reports from our jail management system.
I'm going to show you first what's been marked as State's Exhibit 357. So that's the Washington. Yep.
And my exhibit
Ask
number
if you
2
are
is
familiar
Nicholas.
with this 2-page document.
Hi, Nicholas. How are you?
I'm doing okay,
Yes,
I think.
What is that?
Good.
It's a housing history report for Marquand, Washington.
Is that an official document of the jail generated by the system that you've mentioned?
Yes, it was printed from the jail management system.
And is that a system that you regularly utilize to try to gain information about where inmates are located?
Yes, it is.
Do you find the system to be true and accurate regarding the reports it generates within your work experience?
Yes, I do.
And how many years have you been a person who operated this
I
system?
think she's
or
going
the
to testify
equivalent
about
system
where snitch and anti-snitch were housed in relation
I've been
to each
involved
other.
in the records booking part for 22 years.
Turning your attention to State's Exhibit 357, does it appear to be changed or altered in any way from the document you produced upon the request of the DA's office regarding inmate Marquand, Washington?
No, it does not.
So it appears to be unchanged other than the sticker that is attached to the document?
Correct.
I'd move admission of State's Exhibit 357, Judge.
Is there objection?
No.
Receive.
Ms. O'Hanlon, utilizing Exhibit 357, can you indicate, first of all, what block that Marquand, Washington was in from the dates of February 2nd through February 6th of 2022?
Mr. Washington was housed at our detention center. He was in H South block, H West cell, bed 9.
And is that a security area, if you know, of the detention center?
That's our segregation unit.
Okay. And again, the cell number was?
The cell which was H West, the bed was 09.
And in that particular area of the detention center, when it says bed, does that mean, does that actually also mean cell number?
Yes, because H West is broken into cell blocks, and the bed number would reflect the assignment on the bed.
So there are not multiple people within a cell within a specific room in those locations, correct?
Correct.
Okay. So bed would mean you are in a specific cell under yourself.
Correct.
Okay. You indicated 09. Did I have that right?
Correct. 09.
I'm now going to show you what's been marked as State's Exhibit 358. And first ask you the same question. Do you recognize this document in the context of what we've been talking about?
This is the inmate housing report for Niklas McAtee.
Generated using the same system?
Correct.
Believe that 358 is true and accurate based on your experience and based on observing this document?
Correct.
Any changes or alterations other than the sticker that you see in Exhibit 358?
No.
Judge, I'd move admission of 358 based on the testimony.
Is there objection?
No, Judge.
Receive.
And if I ask you about February 2nd through February 5th, 2022, up until 2:14 p.m., are you able to indicate inmate Niklas McAtee's location, again, from February 2nd, 2022 through February 5th, 2022 at 2:14?
Yes, he was housed in H West, bed 20, or cell 20.
So 20 as opposed to number 9, which was Mr. Washington, right?
Correct.
Okay. And then on February 5th, from 2:14 p.m. to 8:35 p.m., so 6 hours and 21 minutes, is there a movement to a different location within that same cell block?
Yes, that'd be cell 11.
Okay. And then at 8:35 p.m. On February 5th, is there again a move to a different location than number 11?
Yes, cell 22.
Okay. And again, those are also in the segregation unit, as was Mr. Washington?
Correct.
I have nothing else of this witness, Your Honor. Thank you.
Any questions?
Yes, thank you. So, Mr. Washington, based on these records, Mr. Washington and Mr. McAtee were housed in the same unit, that being H cell block, from February 2nd through February 6th of 2022.
Correct.
Nothing further.
And Ms. O'Hanlon, and it was only in those 4 days that they were in segregation together, is that correct?
Without itemizing the whole report and going through each cell location and transaction date, I wouldn't be able to tell you off the top of my head if they were housed together elsewhere.
You're not aware of any other time they were in segregation based on what you've been asked to look at?
No.
Nothing else?
The question was asked in such a way that the no could either be saying no, they weren't, or no, I'm not able to tell.
No, I'm not aware of any other additional times they were housed together.
Thank you. Any other question?
No.
No.
Mr. Stone?
Well, that didn't fill up too much time.
I think we're back at.
I was informed that our next witness has walked into the courthouse.
Oh.
No. Okay.
Oh, good. All right.
For the record, this is going to be Connie Hillman.
Is it one or two cops who have skipped town for testimony?
On the record, I'd like to move into evidence exhibit 299 and 300. This was the jeans and the white t-shirt.
Is there objection?
No.
Received?
Okay. You asked something a minute ago, Nicholas, I couldn't hear.
Oh, I asked, is it one or two cops who have skipped town for the defense?
One.
Okay, only one.
Yeah. Another, they have another witness that has a cold. They have some sort of flu or something. All right, here, let's get through some of these here real quick. Bondian, yes, both unavailable witnesses are cops. I thought only one was. Well, then one is out of state and one is sick. The smells of DA interference, just like from the first time he didn't turn over evidence to the defense. Well, let's give him the benefit of the doubt. I'm not sure why. We answered your question that we answered your deal here. Me, I prefer, as far as rum goes, I like a Havana Club Maestro Selección. Lovely Cuban rum with my Cuban cigar. Or anyways.
I prefer
Boomer
rum
millennial
with cigars because it has some sweetness.
Yeah. Anti-Snitch said Snitch was second level. Snitch said first. And I think we've heard some interesting stuff we'll get here to in a minute. Illegal Vice says, Nicholas, I think Jeff needs to find some more whiskeys, or you may have to send your kinsman to South Korea to say hi to Legal Vices. I've got my whiskey right here. Oops, except for now I didn't put the cork back on. Now I have less of it in the bottle and more of it on the side of my chair. All right.
Favored teams in the NCAA.
Yeah, I don't think we care about that. Thank you for taking that down. Carol Fro says, wait, isn't it the defense's witness? Yeah, this was the prosecution's witness because all of the defense witnesses are either not available today or are scheduled for later. So they just took things out of turn and they brought in one of the prosecution's rebuttal witnesses. Just out of order. It happens occasionally. But luckily we don't have to wait an hour because their next witness has apparently just walked into court. Yay. Kelly R says, I worked in a prison for years. Inmates can easily communicate by fishing, even in different pods. Yeah, or you use string and lines and whatnot to pass the notes from cell to cell. But here they were saying they could talk very easily back and forth. They said it was about 28 feet between the two cells looking at each other, and you could whisper and be heard. But they were also saying that when someone's out of their cell, they can walk around and talk to other people in their cells. So communication was apparently pretty easy there. And again, yeah, Wolfran says, but anti-snitch did not specifically say that the snitch discussed jumping cases while in the cell. He spoke to him in the common area as well. In the common area, yeah, they could walk around to other cells and talk. Plenty of opportunities. Illegal vices. Yeah. Illegal vices. My name is Brandon. Again, said, so I go on Ancestry DNA this week, and my father's side is 100% Irish. My mother is 0%. I'm 46%, but also 4% Norwegian. Thanks, cousin Niklas. He's Swedish.
Hi.
He's
so
Swedish.
You had a visit.
Blame the Swedes.
So my ancestor paid a visit, apparently. Yeah.
So again, how can you not have your witnesses ready, DA? Like we said, yeah, wasn't there a witness? Jeff, can you testify as an expert witness on long pig? It's long pork. That's the old euphemism for human flesh. We were talking about cannibalism earlier in my Maritime Monday stream.
Oh, I knew that sounded familiar. Like long pig. Yeah.
Yeah, long pork.
I know a little. I studied anthropology, so I know a little bit about stuff like that.
Speaking of
all right. Yes.
Do you two know what a Swedish umbrella drink is?
Is it a sex thing?
Familiar.
No.
Okay, then I don't know.
Oh, let me show you here. 1 second.
Unless it's like a girly cocktail with a little pink umbrella in it. Okay. It's got a twisty straw. Okay, yeah. So far, it is a girly drink with a little straw in it. Convince me otherwise.
I love the props at the ready.
There you go. Just put it in the bottle. That'll work. What is that a bottle of?
This is Dvorek vodka, the cheapest in existence, and orange juice.
That will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Please be seated.
So it's a healthy drink.
Good morning, Ms. Hillman. If you don't mind just stating and spelling your name for Madam Court Reporter.
Connie Hillman. Connie L. Hillman, Hillmann.
And Ms. Hillman, how are you currently employed?
I am retired.
Very nice. What did you retire from?
I owned D&M Accounting Services in Menominee Falls. I'm an accountant.
And can you explain what D&M Accounting Services, what that business entailed?
The accountant.
Mainly doing personal tax returns, corporate tax returns, a lot of monthly bookkeeping, payrolls.
And how long did you have that company for?
32 years.
And were you the owner that entire time?
Yes.
In your 32 years in business, did you ever have a client named Zachariah Anderson?
I did.
Okay.
Don't smile like that.
Today?
I do.
Can you briefly point him out and describe what he's
They had a
wearing?
thing going. They're smiling at each other.
Gentleman sitting next to you and looks like a gray suit with a blue
Pointing.
gray tie.
Pointing at the accused.
Judge would ask that the record reflect that.
Right.
Thank you. So, you know Mr. Anderson, approximately how long had he been a client of yours?
I'm going to guess 2 years.
Just for record purposes, since Detective Correa is not here, I am opening what's been previously marked as Defense Exhibit 242. Ms. Hillman, in your 32 years, I'm assuming there were certain business practices and procedures that you utilized as far as keeping track of clients' information, things of that nature?
Yes.
if someone were to do taxes with your accounting services, can you please explain to the jury the different
Oh wait, I forgot the
ways
cage.
that your clients could come pick up their tax returns?
Objection as to other varieties of ways. Certainly something specific to this case, but irrelevant what other ways are available.
Overall.
People can show up personally to pick up and sign the documents that give us permission to e-file their tax returns. Before we e-file a tax return, we need that signature, and they have to pay us either cash, check, Visa, MasterCard, Venmo, or PayPal.
And do you provide a receipt for that transaction?
Only if it's cash.
I'm just going to show you a couple of papers.
Okay. Now, the reason they're calling her, if you recall at the beginning, part of the D's opening was that he was missing and gone for a 3-hour period the day that the murder was supposed to have happened, the day after the murder was supposed to have happened. And she said, well, yeah, that's because he was in another city picking up his taxes. And I guess this is the lady that's going to be testifying. He was there picking up his taxes.
Okay, again, this is Defense Exhibit 242.
Some paperwork that he had been doing with her was found in the car, and I believe that was part of the mistrial, that the defense did not turn that over.
Yes, that is a receipt showing that the gentleman paid with cash.
Okay, and is this receipt, is that the type of receipt that your business utilized?
Correct.
And what would the date indicate?
May 18th of 2020.
And what would that indicate to you? What was done on that date?
That he picked up his, looks like his 2019 tax return, which I'm going to guess was more than likely filed for an extension because it would have been due in April.
Okay. And then under this receipt is a document. Does this look familiar?
Yes, that's our tax return cover sheet that we put on every tax return that we do.
And it looks just like the ones that you do for your tax returns?
Yes.
And you had noted already that you did in fact prepare Mr. Anderson's taxes for the year 2019?
Correct.
And the address on this tax return, is that the address of your company?
Yes.
I want to show you this piece of paper.
This is an alibi witness, apparently.
Does this look familiar to you?
At least a partial alibi witness.
Can you explain what this is?
It's just so that people have notification from us that they have 24 hours to look over their tax return. And if we don't hear from them regarding any changes, then we go ahead and e-file it. And then they can also log into a program we use called Secure File Pro, and that's where we store all PDF copies of tax returns for clients so they can download them at whenever they want.
Okay. And based on all these records and the receipt, is it your understanding that Mr. Anderson picked up this tax return packet on May 18th, 2020?
Yes.
Now, I want to talk a little bit about where your business was located. Was it a standalone building or was it in a strip mall? Like what kind of, sorry, it's very loud, hold on. What kind of location was it?
It's in a Tri-City National Bank. It's a standalone building, and we lease the whole lower level of the Tri-City Bank.
And around May 18th, 2020, did you have any surveillance cameras or any security
believe we had security cameras, but we would not have had footage from that time frame, now.
Now, or closer back to May of 18th, 2020, did law enforcement ever come to your business to obtain that surveillance footage?
No.
Did law enforcement ever talk to you at all in this case?
No.
I have nothing further subject to redirect.
Ms. Tillman, did you specifically speak to Mr. Anderson that day?
No.
So someone on your staff would have.
Looks like the shout out Mapes is the
Right,
court
the
clerk
name
there
on
for
the
all of you
receipt
Dune
was
fans.
Veronica, Adamoy. She was the out front receptionist person.
Was there also a sticky note on the supplemental page about when you would e-file the return that indicated will stop in 3:24 p.m. call?
That's Veronica's handwriting saying that she called him and that he must have made a notation saying that he would be in to pick it up.
And so that would be on the 18th, correct?
Right.
So at some point, she speaks to him at 3:24 p.m. and he says he'll stop in that day?
Right.
So then, per logic, he would stop in subsequent to that sometime a little bit later on? Okay, so if his phone records put him in Menominee Falls at 4:52 p.m. on the 18th, that would be consistent with him picking up his taxes from Menominee Falls on that day at that time?
Duh.
Um,
That was a brilliant question there. Is 450 something after 318? Yeah.
I have nothing further. Thank you, Ms. Hillman.
Nothing further from this defense.
You may step down. Now, when do we next have witnesses available?
Good question.
Our next witness won't be here till 11:30, Judge.
11:30. So that's like 35 minutes from now.
Morning break, what do you think?
It's a very slow morning.
During the break, we brought you this on the trial. See you in a little bit.
A little bit. That's a great definitive question. So we got at least 30, 35 minutes before we all come back into court here. Get rid of that. Get rid of this. And get rid of the court. Who knows? They'll be in and out and in and out and in and out with pulling up the audio so they can talk about the NCAA and whatnot. We got a lot of stuff going on here. Let me clear off the super chats we've got, and then we can get down to talking. Matthew Self said, just shot you an email with an idea for a brand overlay for StreamYard. I included one with and one without the cage. It would deeply, deeply appreciate it. Here isn't, well, guess we can't show it because we don't have the, well, we can do this. This is sort of it in action. That's the normal one. And this is the where's the new one? There it is. Boop. Yeah. See, get the little legal vices banner up there. Pretty darn cool. You can see it in action.
The banner's great.
Yeah. That's pretty darn cool. Thank you. Thank you, Matt. Wow. Oh, what the hell is that? Okay. And Tara Rayner, Sadie appeared to regret saying both twice. It was the cars. Yeah, is that what we were talking about? The time she said both of the alleged victims' cars were present, but they only took one of them. They only seem to have been interested in one of them. I don't understand that. But, oh yeah, here we go. Tara Rayner again. Yeah, going for an injection in my neck today. Yikes. Good luck with that. I don't know what it's for, but injections in neck suck. But have a clip of Sadie saying when she arrived to Junior on the 19th, both of his cars were there. Only truck towed to evidence. Any idea of the second car? No, this always just makes sense. Weird. And Chris Mullen, what does this have to do with anything? Again, potential alibi witness, because the DA was making a big deal about how he was missing for 3 hours, unaccounted for, how he allegedly, they say, killed him, then ran off to this mysterious construction site for a few hours, and then disappeared for 3 hours, and then suddenly reappeared. So they're saying he went to work, he bought some stuff at Walmart to go for the purpose of going to demolish this house and cleaning up, And then after that, he went to pick up his taxes, and then he went back to his house. So it's a potential alibi witness. That's what that had.
The prosecution is trying to insinuate that he was disposing of Rosalia's body the day after he was supposedly killed. The problem is that, well, he didn't really have time to do that. And we can account for his whereabouts on the day that he was supposedly disposing of the body. So that hiding
The judge
and corpse
looks
charge.
subdued. Yeah. The judge looks subdued in this trial. He was feisty and written. He's been pretty feisty in this one. He's the feist is there. The feistiness is in place. All right, so we've got a little bit of time. I think we can go back to what we were doing earlier and showing the witness from Friday, the anti-snitch. Assuming I still have it. Yes, I still have it pulled up. So we can pull the anti-snitch here. But first, just want to do our little midstream grift here. We have Chandler Remington, who's been here since day one through thick and thin with AussieOverlawd, Hayden, and I. You can check her out and follow her on Twitter.
Or you can actually subscribe to me on YouTube. There's that.
We'll get there. You can subscribe to her on Twitter. You can follow her on Twitter at Remy _REMY_legal. Remy _legal. Or her brand new channel on YouTube, which is...
It's just my name. It's just Chandler Remington. You can look me up. I will
It's just Chandler Remington.
send you a link. Yeah, I'm brand new to the YouTube thing, so everybody go and subscribe. And I'm looking forward to putting up a channel intro video soon this week.
Awesome. Oh, Flux has touched down in Salt Lake City. Salt Lake's a beautiful, beautiful place. Well, welcome to my neck of the woods. Welcome to Salt Lake City. You said you had a 45-minute layover there. Enjoy. Look out at the possible snow. And we have Niklas Starow, Union Rep guy. Union Rep labor lawyer who has just hit 1,000 subscribers. Now you're what, like 1,200 now? 1,300 now?
1,230. So I zoomed past that 1,000 during this stream on Friday.
And your camera seems to be frozen. Or you're a very good ventriloquist, one of the two.
It's working from my end.
There, now you're working.
Yeah.
There you are.
You were frozen. And
Yeah.
how are we on view hours? Are we doing good?
We are doing quite good. Before my stream last night, I had around 1,200 watch hours, and now I have 1,600 watch hours. So it's
awesome
on the way. And if and if I reach if I get the cash before the beginning of May, I will have a birthday stream, and
cool.
That will be fun.
Cool. So
But,
everyone head on over to Chandler Remington and subscribe to her channel. And what are you going to be covering there, Chandler? What sort of things are you going to be doing?
Well, my Twitter platform is largely based around my very strong view that misandry and misogyny are equally disgusting and harmful. I like to advocate for men, for men's rights, for men's mental health and well-being. And I like to acknowledge that men suffer from the same things that women do. Men suffer as victims of domestic violence. Gendered issues are very important to me, and that started with the Depp trial. So I'm going to be covering things like that, and I'm looking forward to it.
And Niklas, what do you cover on your side?
I cover Viking travels to Ireland. No, saying hi. No, I do union stuff and labor law, which very few people watch. So I cover current events. I cover the Andrew Tate case. I cover, well, this now, Zachariah Anderson, and a bit of everything that I can get my hands on that I feel I can have an input on. Yeah.
And see, he's not doing himself right there. Let me tell you, Niklas is a master storyteller. And if you don't believe me, how many of you could think that a story about a warehouse construction would be interesting? One of you needs to turn off your phone alerts.
Yeah, that would be me. Yeah,
Okay.
We're having a Schroeder moment in the panel right now.
Yeah.
Let's have a boomer moment. How the frick do I turn off this crap?
He has a great story of non-compliance in building a warehouse, which is actually really, really entertaining. So go check him out. And for those of you that are here with me, the 2,270 of you, there's 1,500 likes, which means there's like 700 of you that haven't hit the like button. Please get down there and smash the like button. That would make me very, very happy, as YouTube likes to be liked. So hit the like button. That'll get us up there on the YouTube's radar. They'll put us out in the algorithm, feed the algorithm gods. That'll bring people to the channel. And we are way better than Law and Crime, even though we're pirating their stream. We're still better than them.
Our chat is definitely a lot better. So.
Well, so are we. We're better than their commentators by a mile. And I'm in the process of pushing to 36,000 subscribers. We are 150 subscribers away from 36,000. If you haven't subscribed to my channel, now's the chance for me to ask you if you would please kindly reach down there and hit that subscribe button so that we can get me to 36,000 and continue our march to 50,000 subscribers. My goal is 36,000 by the end of today. Just need 150 more of you to subscribe to the channel. I know that's a lot to ask, but we usually get about 750 unique views during any particular live stream. So of that 750 of you, 1 in 6.5, just reach down there and smash that button. And then take our like and subscribe poll. How are we doing on the poll today? Did you hit the like and subscribe button is the question. 18% of you said, oops, I did now that you mentioned it. 22% of you said yes, like Schroeder hits his oranges. We know he loves to find oranges in his man purse or in his robe, wherever he stores them. 24% of you said yes, let's get to 36,000 subs. And in first place so far, 35% of you said yes. Keep it simple. We'll check back in on the poll in an hour or so. Matt Bond Chandler, will you be interested in Australian cases?
Yes, absolutely. I'd be very interested. Send me a DM. I think my DMs are open on Twitter. That's my wait. I have to. My camera's reversed, so it's right there. Remy_legal. I'm gonna see if my DMs are open. I'll open them up for you if you want to send me a message about whatever the case is, and I'd be curious to know more.
At least I'm assuming that's what AUS cases. This could be Austrian. Yeah. And Matt Bond asked, what will you be covering, Chandler? Actually, I forgot to bring that. I saw that and I didn't realize it was a super chat when I had it started. So that's why I asked her the question a little bit earlier. And want to see a good DA? Must be at least one, right? Well, if you want to see a very, very good prosecution where they did an amazing job, go back into my playlists and look at Florida versus Terry, a guy that was accused of assaulting and stabbing his girlfriend in the face repeatedly and then slitting her throat and killing her. The prosecution did an amazing job with that case. They played it fair. They played it good all the way through. I had no problem with them. And even hypercritical Stephen M. Gosney only had one complaint about one thing the prosecution said during the entire case. Excuse me, as I choke on my own saliva. It was a textbook case of how a prosecution should be handled. No shenanigans, no unfair questions, no trying to sneak things in. It was a beautiful, beautiful case from a prosecution standpoint, and they clearly crushed this guy, and he's never going to see the light of day again as a free. So go back and look at Florida v. Terry. It was a short trial. It's good to watch.
Yeah, that's what they are supposed to do. Bring evidence, present evidence, not the absence of evidence is evidence. No.
Yeah, that was our argument last time. If you snitch on a snitch snitching, are you a snitch? Yep. And Zenith Anderson Sadie say 2 cars March 13th at 6:08:27. Okay, there's the timestamp. And Cameron Mason. Not that it's going to do anything, but I filed an ethics complaint on the DA for him mouthing stuff at witnesses.
Yeah,
Okay.
probably won't. Yeah,
I mean,
probably won't.
Bigger violated the Fifth Amendment in Rittenhouse, and he wasn't disbarred. So, I appreciate the effort, and I think that that's a good thing to do. But will it go anywhere? I'm not sure.
I'm kind of the opposite. I kind of think you just let them do it. The prosecution is involved in it. The prosecution knows what he did. The prosecution knows it. They have like outside third parties doing things like this. I don't kind of interferes with what's going on there. I think, but I can't tell people one way or the other to do something or don't do something. I just wouldn't do it because I'm not a party to it, and it's there's other people that are parties that are aware of it. But like I said, you do you. I can't say do something or don't do something. I wouldn't.
Well, Schroeder knows. The defense brought it up. They were able to go over the video, in court. I love that moment where Schroeder was like, "I'm keeping this for later." That was fabulous. That was really
he keeps
funny.
the thumb drive.
I was watching when Danny was saying, "Oh, no sanctions," but we'll see. Something could happen. So they're aware.
Yeah, and so where we're sitting in the trial right now is it seems like there are 2 witnesses for the prosecution, for the defense left. Then the prosecution will start their rebuttal. And like I said, we could be done with this by Thursday. I can't see it going past Friday, especially if everybody sticks to schedule. So it could be the last few days of this 4-week, 2-week trial.
Yeah, and if you're still with us on Thursday, Jeff and I do we do the O.J. Simpson trial. We cover that Thursday mornings. We skipped it last week, but we should be doing it this week, right? So you can look forward to seeing me there very early in the morning in California.
Very early. Very, very early for you.
Sorry, I had to do a mini grift, but
Go ahead. And Tara Rayner, Legal Vices, you should play. It seems like an oops. We might be able to get around to it. We're going to jump right back now to the guy the anti-snitch. I don't even. All right. Well, hang on. As soon as I read this, from Totally Not a Russian Bot, Jeff, you've popped my drunk pocket phone ban cherry last week. Love you too, bro. Were you one of the people that got timed out in my sleep? That's how much I hate you, chat people. For those of you that weren't around last Friday, after we turned it over to AussieOverlawd at the lunch hour, I went to sleep. And I had my phone on the pillow next to my head. And I guess at some point I rolled over on it, or it slipped down and I touched it, and I apparently timed out and or banned about a dozen people in my sleep.
Oh God,
so.
you did?
Yes, and Hayden unmodded me, so I couldn't continue to ban people. And I woke up to
hilarious.
A bunch of people. Valhalla awaits.
You ban people in your sleep.
Valhalla awaits says, Legal Vices made me work harder in that stream than all my other modding combined. I thought it was kind of funny. I woke up to lots of nasty text messages and Twitter DMs and everything, but it was fun because I was asleep and you were all having fun. All right. Picking up where we left off, we have the prosecution and the defense going at the anti-snitch snitch. The anti-snitch snitch is he's on the stand to counteract the previous snitch, Mr. Munch, as they called him, about his testimony. And the defense is putting on a very, very cool argument, I think. But the prosecution, the district attorney, doesn't want him to say anything because everything he says is bad for his case. And they were asked, where we left off was he was asked the question, did anybody talk to you or offer you anything in relation to this case? And he said, yes. And the defense lawyer said, well, who? And he said, the prosecution. And he said the prosecution offered him something and made him a promise if he testified. And that kind of short-circuited Judge Schroeder's brain a little bit. And Judge Schroeder said, so, wait. You mean the federal government that's prosecuting you for your crimes, right? And he's like, oh, no, the state. Like this dude right over here, he offered me something. And now they're trying to wrap their mind around this. And that's where we begin. Right after I read Jonathan, Chandler Remington is possibly the best not used action hero name ever. Chandler Remington, the Unforgiver.
I really like that.
And all right, here's the question. Oh, go ahead. Sorry.
Oh, nothing. I just I'm a forgiving person, but I like the Unforgiver. That's pretty cool.
All right, let's start this testimony.
Yes. So
All right, we'll back up a little bit.
I will.
I know you won't disappoint.
Thanks for the confidence. Mr. McAtee, the court just spoke with your counsel, Mr. Ahmad. Is that right?
Yes.
So he's here in the courtroom. So as I ask you questions, or as Mr. Gravely asks you questions, if there's a time that you feel that you want to confer with him, feel free to ask, okay?
Yes.
Now, have you had time to talk to Mr. Ahmad about your testimony here today?
Yes, I have.
And do you feel like you've covered everything in terms of how this relates to your current legal situation?
Yes.
And do you have any questions for me at this moment in time?
No, I do not.
So getting back to what we were talking about before in terms of there's no agreement right now, but at some point there was some sort of offer?
Objection. This is irrelevant, and there is absolutely no way that there's relevance in this situation, Judge. Calls.
Yeah, see, this is here is the district attorney not wanting him to say what was offered or by whom for a very good reason.
For hearsay,
I don't agree with you. The objection's overruled.
Was there a point where your understanding, without saying who said what, but your understanding about whether or not there potentially would be a situation where you would testify for the prosecution?
Yes.
And what was your understanding?
My understanding was that.
sorry, sir, I apologize.
I'm sorry, but could he finish his answer? Wait.
He wants to make an objection, I assume.
Yep. Objection. It sounds like it calls for what his attorney has informed him, since I'm not aware of any other basis, and that would be hearsay and would be an improper area.
Do you want his attorney to testify?
Well, I would suggest to the court that Mr. McAtee is not the person who should be able to report that, because it is hearsay and is not appropriate for him to talk about that.
Well, then Mr. Gravely is going to be a witness because.
No, please.
Well, no, because.
Please.
Before the
Don't get brazen with me.
Never have that enough.
I love Spicy Schroeder.
It's not hearsay because it's not being offered, I assume. Well,
Make a Dr. Spiegel face. Thank you.
well, it is hearsay, but I think it's an exception under the what is it, subsection 4, intent plan.
Okay, now this is an interesting thing here too. Carpe Diem says, beautiful call out by the defense showing that the anti-snitch's lawyer is present in contrast to Munch. Yeah, Munch's lawyer was nowhere to be seen. Clearly, he didn't want to be there, which the only reason I can think he wasn't there was because he wanted to have plausible deniability that his client was lying about stuff. But the anti-snitch's lawyer, the guy that's on the stand now, his lawyer, if you watched the Edgecombe case, or the road rage case where the guy shot and killed the immigration lawyer, with the legendary cross-examination in that case, the direct and cross in that case was horrific. The lead defense lawyer was, what was his name? His name was Biivri, can't think of his last name, Biivri somebody or other. But his co-counsel, Ahmad, is this guy's lawyer. So, there's a confusing story. Yeah, Lamar, Biivri Lamar, that was his name. So yeah, Biivri Lamar's lawyer, his co-lawyer, Ahmed again, his last name just goes off in the ether somewhere, but his co-counsel is this prison snitch's lawyer. Yes, B. Ivory is the Edgecombe case. That's what I was saying. It's B. Ivory Lamar. I was trying to think of his last name. So, yeah, that Ahmad. Exactly. Yeah, his B. Ivory's co-counsel that was also in on it. He's this guy's lawyer. So that's just a little tidbit, throwing it out for those of you that watched the Edgecombe trial and somehow managed to get through that. And alrighty, I ban punks like you in my sleep, Jeff, probably. Yeah. And one thing before we jump back into this, I hope the defense objected to this out of order rebuttal shit. This out of order rebuttal shit it happens all the time. If you have some time and there's a witness that doesn't show up and there's a gap and one of your witnesses is available, you'll take them out of order. It is not uncommon. And there's nothing wrong with it. And the defense agreed to it. That's how they could do that. The defense agreed that it would be wise to do it that way to save time. So yeah, that's not shenanigans. That happens all the time, and the defense agreed to it. All righty. Borowski made everything better.
Take a look at the statute.
There he is back there. I guess we can fast forward through the pauses, huh?
Okay.
Okay.
Sub
90801.
3, 908.03 sub 3 are not excluded by the hearsay rule. Sub 3, a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition such as intent, plan, motive, design, mental, feeling, pain, and bodily health. So the question is really inquiring into whether he's been asked about whether there had been a deal discussed.
See, why wouldn't the DA want this
Gain
in?
awareness of that through his attorney, but it's not being offered to prove that there was a deal, but rather what his intent was. So the objection is overruled.
You can answer if you remember the question.
Yes, I was offered consideration on my federal case or testifying for the prosecution if I were to.
Did you consider it?
Yes, I did. Very seriously.
So that's it right there. That's why the district attorney, that's why he did not want this guy to finish this sentence. Because they came to him first. The prosecution, did I say defense? I hope I said prosecution. And the DA came to this guy first and asked him to snitch first. And he said no. So then they went to Munch as their number 2 guy. So I think this is
Jeff, I have a question.
Yes.
So it's my understanding that what the DA offered him was not something that they had the power to offer. Is that correct?
It's the same thing that they offered Munch. You testify for us in this case, and we'll put in a good word for you with the feds.
Okay, I see. So
you're
they
helping
weren't
us solve a
offering him-
crime.
because they don't have the power. They would have to go to the federal government in order to get charges on a federal case, changed or dismissed.
Yeah,
I
and
was
just
just
they're
curious.
still like you're helping me. You're helping the good guys. You're helping solve a crime. So that's kind of fun. I just like that they went to him first, and he said no, and so then they went to Munch and got him to testify. And now he's testifying that the DA came to him first and he wouldn't do it. And so they went to the guy that told him that they should just lie and make up shit to get their case reduced.
Got it. Thanks for clarifying.
And yeah, and see, the thing is, he is in an inherently believable position where he gets nothing out of this testimony here. There's nothing that the defense can do to help him out. So that kind of lends a little bit more to his credibility.
Yeah, and it ruins the first snitch to ever testifying ever again.
Yeah.
Even in the previous snitching events he may or may not have been involved in. Would that be a grounds for appeal if another of his cases relied on his testimony?
No, I mean, you can still argue that he was truthful in those cases, and he's truthful in this case, and this guy's lying. I mean, yeah, if you can prove he's lying, that's a problem. But this guy, I don't know, he's still a criminal, but he doesn't really. The only reason I guess he would have to lie is that he hates Munch or he hates the prosecution. But the DA, the defense can't give him a deal. But I think his testimony is very, very interesting.
So I'm going to back up and come back to this. There was a time when you were housed with Zachariah Anderson, right?
Yes.
Do you remember when you were, was there more than one occasion when you two were cellmates?
Yes, on 2 different occasions.
So
see, that's why they wanted to come to him
remember when
first.
the
He was
first one
cellies
started?
with him twice, and Munch was only once
Yes,
for
it
about
was
5
in
weeks.
August of 2021, roughly October of 2021.
Okay, August to October 2021.
Yes.
And so when you're, was this in just general population?
Yes.
So when you're in general population, how much of your time is spent together? Some regulation about that?
Now this
Clock
guy's
down in the
no,
cell is
he's
roughly
he's no
12
saint.
to 14 hours on a general population dorm.
And so, needless to say, you spend a lot of time together.
Yes.
So did you get along with him?
For the most part, yes.
Did you, was he forthcoming about his cases or his case?
Objection, state be taper.
I don't know how that applies here.
I'm not sure it does either, but I do think the objection is well stated.
Okay.
This is irrelevant based on state be taper.
So
I'm not sure I agree with what the case you're citing, but I do agree with your legal principle.
Thank you.
So, so you got to know him though over that time period?
Yes.
And can you tell us what you observed about his sleeping habits?
You remember that was the big part of Munch's testimony was he was asleep, and then he started shouting in his sleep, "Die, die, die, motherfucker!" And so therefore he committed the murders. That was Munch's testimony. And he
So
jumped
dramatic.
he jumped off his bunk. He looked me right in the eyes and said, "I did it."
Totally believable. Just,
Yeah, so,
I mean, why would he lie?
right. And so this guy's going to try to talk a little more about his sleeping habits and whether he was prone to, I assume whether he was prone to nightmares or talking in his sleep. But the DA is also very, very objection happy because he doesn't like the testimony.
He slept roughly 4 hours a night, 5 hours a night. Not anything abnormal.
Was there ever a time when he would have nightmares or wake up screaming?
Objection, same thing. Irrelevant based on case law.
It's kind of relevant.
I guess I do follow his rationale now. It's a Tabor type incident. Pardon me? Well, why don't you give me the citation?
Okay.
Now they're going to argue about case law here,
The
and
facts are,
We making legal argument too, or are you just being asked to
Nope.
see the
Ask
case?
for the case citation.
just asking for the case. There is, the most recent is a 2019 case. It is unpublished, but the facts are so remarkably similar that I'll give it to the court at least for support. At State versus Yost, Y-O-S-T, 2019.
and they get the
YOS.
Paragraph.
judge going to skim through the case.
There's reference to a general rule in, as you see in that paragraph, Osseth versus Farmers Mutual Insurance, going back to 1959, talking about the general rule, as you can see, is that when the absence of a statement.
No, stop.
Okay.
Stop.
Gotcha. I'm not trying to argue.
Yes, the absence of evidence is evidence. Well, that's what the defense is saying. They're saying it's very okay, and they're showing case law saying why it should be allowed in.
Yeah,
I'm not finding the case.
And they gave the wrong citation.
Stop. I'm gonna try again.
My objection is not a hearsay objection. I apologize. Counsels, I think that I've made a hearsay objection. I have not. State v. Tabor is about whether this is relevant evidence, Judge. The court ruled in Tabor that this is irrelevant, and there's a whole line of cases that talk about that.
Well,
we're not talking about the hearsay object.
But in Tabor, it dealt with, the victim versus the defendant. This is two witnesses. So it's completely in opposite to Tabor's holding.
We couldn't find it either.
No, I have it. I just.
Yeah, but not
Paragraph
the
58,
paragraph.
so
Yeah.
it doesn't exist.
Right. I did.
Exciting back and forth here.
Sadie's so festive. I didn't notice the shamrock scarf.
Yeah, it's this was St. Patrick's Day.
The objection is sustained. Because all right, the objection is sustained.
See, this is the thing I don't know what happened. Somebody got thrown out of court there, and I don't know what that was all about.
I think that guy was drunk. That was what I heard.
Is that what you heard? Yeah, he was like apparently shouting something, and
He was intoxicated, and he was making a scene. He was being disruptive, so they removed him. That is my understanding.
Okay. I was wondering about that.
Sustained.
It's not the first time this happened, so I might be mixing up incidents.
All right, the objection is sustained.
Anything that can't happen has happened in this case.
Sorry, I'll state for the record that for once I agree with Mr. Gravely.
Well, then I object.
Yeah.
No, I'm objecting.
That's kind of cute.
All right.
So,
A little moment.
Mr. Mack.
I'm sorry. I've been surprised the jury hasn't made a run for us, Judge, much less people in the audience. But
Mr. McAtee, I believe you said your first time.
Anyway, they get this in, and unfortunately, it's like I was curious about what the State v. Tabor was all about, And unfortunately, I really can't say anything about that case and keep this stream anywhere remotely monetized. It is a horrific case. Just look up Wisconsin State v. Tabor, Tabor. I mean, it involves every sort of horrific thing you can imagine happening between an adult and a child. Yeah, there's just nothing you can talk about. It's
Well,
it's
aside from
bad.
that, the reason that they brought it up, I believe, had to do with things that were said in a jailhouse setting. Am I correct? Or I actually haven't had a chance to read about it, but I was trying to glean what they were saying in court.
I'm not exactly sure. It has to deal with with bringing evidence of other crimes and things like that in under
Right.
sort of a wider umbrella under certain circumstances. And like I said, I don't know the full details of the case, and they're pretty horrific, so we can't go over them here to get
Right.
to it. But it's kind of
Well,
a non-issue because they went over it anyway.
I believe that what happened with defense was they were trying to say that that case was irrelevant because because in that case it was something about the the defendant versus the plaintiff, but in this case we're talking about two different witnesses, and so they felt that the case law was irrelevant, and I believe that Schrader ruled in the defense's favor. Correct? I'm not sure. Maybe we should just keep watching.
Yeah, they get to bring it in.
Okay.
So it's because they said we have more newer case law where you can allow these things in. There is live trial. We're on a break. The break should be ending soon, actually. The break could be ending anytime now. So we're just watching this to fill in the gap. Kyle Davis says no. Okay. What?
Okay.
That's a good. Yeah, Boomer Millennial says State v. Tabor says that because a defendant doesn't do something in one scenario doesn't mean he won't also not do that in another scenario. That's what you were talking about, is like evidence of not doing something doesn't mean you didn't not do it in another time. Yeah. But they get to talk about it anyway because they're saying they have a newer unpublished case that is almost the same fact pattern as this case, which allows it in. And the judge says, oh, okay, we had another one. We had a thank you, Jeff, and a no, Jeff, that's wrong. Okay, is another Schrader case that was appealed. I don't know which. We're saying everything. I don't know what that's wrong. Which thing have I said is wrong? I'm not sure which statement it is you're making reference to, but whatever I said, if it was wrong, apologies. I'm not sure which statement I'm supposed to retract, but I retract whatever it is I'm supposed to retract.
So prosecution tried to cite State v. Tabor, and then defense countered with State v. Yost. That's my understanding.
Yeah, which is a newer unpublished case.
And Schrader let it in, so that allowed them to move forward.
The objection was sustained, is what you're saying. Okay.
Well, perhaps if
Sorry.
do you want to continue watching the rest?
What I was trying to do was just trying to get through here.
Frame was with, Mr. Anderson was August of 21 till October of 21.
Yes.
Right. And then what was do people just get moved around a lot? Is that why some of this happens?
Yes.
Okay. So what was the second time frame, if you remember?
Second time frame was
with Mr. Anderson.
Beginning of February 2022.
If I say something wrong,
until
I should apologize for it and retract it and say the
July
right
or
thing.
End of June of the same year, 2022.
Okay. And so when you spent time together, was there discussion about his case?
Objection. Again, it's the same objection, Tabor. So I have an ongoing objection to the point that the court will allow that, indicating that Any statements made by the defendant to him?
Well, I wasn't asking for the contents of the statements or anything else.
Was there a discussion about the case, which sometimes can be loaded with hearsay, but I don't think in this instance it sounds like it. So you can have this question, but
Okay. Was there questions? Was there discussions with him about his case?
Yes, there was.
Okay. Did you feel like you knew a lot about the case?
Yes, I did.
Same objection.
Okay. So
the answer can stand. Go ahead.
all right. So I want to go back in time now to a time when you were in segregation. You call it the hole, right?
Yes.
Do you remember when that was?
Yes, it was January and February to the very beginning of February, most of January of 2022.
And now, can you tell us what the hole looks like just physically when you're in there?
What does your hole look like?
Like a rectangular room, cells that have plexiglass fronts. They're extremely dirty, so you really can't see what's going on. It's
the plexiglass is dirty.
Yeah.
Okay.
But it's very loud. All you can do in there is really talk to one another. There's nothing else as far as books or anything to entertain yourself with.
Okay. And so how long in a given day are you in your cells?
23 hours.
Okay. When you're in that situation, excuse me, physically, I couldn't tell, is there just one level? Is there multiple levels? How does it work?
It's 2 floors.
Okay. Are they just in a line, or is it some sort of rotunda?
It's more like a rotunda, yes.
Okay. Did there come a time when you found that there was another federal inmate in the hole at the same time as you?
Yes, I did.
And who was that?
His name was Marquand Washington.
What did he go by? What was his name? Street name?
Called him Munch.
Munch.
So
Munch.
when you were housed in the segregation unit, where was he in relation to you?
I was upstairs in the far corner in cell 22. He was directly across me, also upstairs, but in the opposite corner.
Okay. And were you able to communicate with him?
Yes.
And how is that possible?
Well,
because yeah, the DA was saying there's absolutely no possible way for those two to communicate with each other. And now he's going to give us his little explanation as to exactly how they did it.
the noise carries in there. So it's, if you talk at a whisper, you can hear it across the dorm.
And were you talking to him because you knew him before, or because he had a federal case, or what?
I had ran into him before in there, but only briefly. We didn't really know each other. We really just started talking because we both had federal cases, and there's not many people in KCDC with federal cases.
So did there come a time when the discussion between you two turned to him talking about jumping on other people's cases?
Yes.
What did he say when that subject came up?
Essentially, he was giving me advice because one of the things that we talked about with our federal cases that we're facing so much time. And one of the ways he said that if you want to get out of your case, the easy thing to do is to just jump on someone else's case. And I had heard the term before, but he clarified and told me more about how to go about doing that.
And did you ask him about, like, to explain that more to you about how he did it or how what his thinking process?
I didn't ask him. He was volunteering his method, I guess you could call it. And he told me what he did. And, you know, he found out information about people's cases and whether it was going through their discovery or just asking them or seeing stuff in the news or newspaper and using that to put himself into it by informing detectives that he had information.
And did he say what he would do if he didn't know something about the case?
He would make something up. He said, as far as he was concerned, it was his life or someone else's. And he said, you know, he would do that to save himself.
So returning to the topic of you, there was some potential mention of you testifying for the prosecution.
Yes.
There, I mean, you knew something about Zach's case by talking to him, right?
Yes, and the newspapers and news.
Okay. Was that tempting for you?
Yes, it was.
What are you facing in federal prison?
Objection. That's irrelevant.
Kind of relevant now.
What?
It's relevant now.
What? What?
Answer.
I'm facing a 10-year mandatory minimum to a maximum of life in prison.
And so the only way out of the mandatory minimum is to do what?
To inform or cooperate with the government.
What's your understanding as to what that takes?
It doesn't take much.
Have you heard this term substantial assistance?
Yes, I have.
What's your understanding about who has to make a motion for substantial assistance?
Objection. It's irrelevant. None of this is happening.
In this case, the state prosecutor, the district attorney.
Well,
no, court is not back, Eliza. If court was back, we'd be watching it.
so if you were to testify in a state case, the actual motion would come from the federal government, right?
Objection. That's leading.
It is leading.
Hold on. It's just indicated.
I love his honesty here. He's like, yeah, it is leading. And it's beautiful. It just kind of shows how much that they're not really listening to each other. Because the defense lawyer asked a leading question. Prosecution says, this is leading. He says, yeah, I know it's leading. And then they continue to argue about whether it's leading or not. And the judge gets upset and he's like, look, I'm agreeing. It was leading. This is one of my favorite exchanges of the day.
The actual motion would come from the federal government, right?
Objection. That's leading.
It is leading.
Hold on. He's just indicated.
I agree with them. I didn't know how else to get there. But it's your perception that if you come to testify for the prosecution in a state case, that is the district attorney that would have to make the motion.
That's leading as well.
Motion?
Or make some sort of assertion.
It's again a leading question. He's just repeated the question.
I can rephrase.
Go ahead.
So what is your understanding about like which level of government would need to act on your behalf in order to get under the mandatory minimums?
He's asked, that's been asked and answered. He's already said that the state prosecutor files a motion.
Well, is that really true?
No.
No.
No, it's not, but that's what he's offered the court.
For some,
no, he has a false understanding.
I myself don't know the answer, but it would be my impression that the United States Attorney would file the motion on the representations made
That's
by
correct.
the local district attorney.
That's correct.
That's not what you asked.
Well, yes, what his
I
understanding
was trying
was.
not to be leading as much as possible. So I can certainly ask that question as a leading question.
Go ahead.
Okay. So it's actually the United States Attorney's Office that files the motion based on its discussions with the district attorney in the case you testified, right?
Yes, it is.
Okay. And you decided to forego that and testify on behalf of the defense.
Yes.
What benefits would the defense, testifying for the defense, offer you?
None. Nothing.
Are there any negative consequences to your testimony here today?
Objection.
Potentially.
Purely speculative.
In this context, I think it's a reasonable question.
It is, obviously, he can't predict the future, but he can, I think he can testify as to what apprehensions, if any, he has. So the objection is overruled.
Yes, I felt very scared about what would come of me testifying for the defense. I realize that the district attorney has a lot of power, and that could be bad for me in a lot of ways.
So you obviously knew Zach for quite a long time, and you've been in KCDC. Did you know him to have any nicknames?
No.
Yeah. Let's ask the question. No question forthcoming. Yes, it is past 11:30 there. That doesn't mean they're back.
For everybody confused, it's KCDC, which I believe stands for the Kenosha County Department of Corrections.
Great album, Back in Black.
ACDC are a fabulous band.
We're joking. The sounds of silence. Let's use the sounds of silence in the pre-recorded bit to say, someone who's been locked up, every man lies about what they've done. You have to appear tough, says Morgan does it. Vince Clortho says, explains to, we'll
Did you ever hear anybody
in a
call
minute.
him Houdini?
No.
Never heard anybody call him
Did you
Houdini.
ever hear anybody call Zach Superman?
No.
Have you ever been convicted of a crime?
Yes, I have.
You've been convicted 11 times, right?
Yes, I have.
That's all I have.
Cross-examine.
So, Mr. McAtee, I just wanted to be sure I had the details right about what you said on direct. So,
yeah,
if I understood you correctly.
So hang on real quick here. Again, I'll try to do this one time. Explain State v. Tabor, totally different case law. And why they can't bring it in. This is just going to be this is the last time I'm going to try to explain this because I may not even explain it correctly. My understanding now, the prosecution's witness, Munch, gets to testify what he heard during an alleged nightmare episode by the defendant. He says he directly heard that the defendant was having a nightmare and shouting, die, 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 mother effer. So he directly heard that, so he gets to testify about what he did in his sleep that particular night. Now, it's a problem for the defense because what they want to say, they don't want to say this is what he directly heard. He wants to say that this anti-snitch, during the time they were together, that the defendant never had any nightmares and never shouted in his sleep about dying. So therefore, what the first snitch said about him talking in his sleep and saying was not true. So it's like the absence of something happening to one witness doesn't mean that it didn't happen with another witness. And that was the whole argument. Do we get to let it in? And I stand corrected. The judge said, no, you cannot let this statement of what didn't happen to someone else as being counter evidence to what happened to someone else. I hope that made a slight amount. It makes sense up here in my head, but I'm not getting it out here effectively, I think.
It makes sense to me.
Well, thank you. And Niklas has abandoned us to go make coffee.
So if I'm understanding you correctly, it's basically saying that, because Munch heard this nightmare, in this one instance, and this other prison snitch, this other guy, this witness, just because he didn't ever hear Zachariah shouting in his sleep or having a nightmare, that doesn't mean that Munch didn't hear it because he wasn't present for that incident.
Yeah. That could be the only time in his life when he actually talked in his sleep. But that doesn't mean it didn't happen just because nobody else ever heard it in any other situation. That's the best I can do to explain it. Yeah.
Like the period of time that he was housed with Munch, that they were, cellmates. That was a different time than when he was housed with McAtee. So if McAtee wasn't a witness to that incident, then it's not necessarily ruling out that Munch heard that, even though Munch is obviously non-credible. So.
And here for the truth said, I'm wondering what happened to this witness when he went back. It's a risk. Because like you said, he's got nothing to gain from this, really. Other than the risks. He's only got risks. He doesn't get anything real positive out of it. Unless, maybe he could get some prison cred in it for going and sticking it to the DA and calling the DA out on other prison snitches.
Possibly.
Maybe.
But he's not getting anything off of his sentence, so.
Yeah, not for this. And that's what he's saying. He said that's the risk he runs, is that the DA has power in the town and may be able to influence his case negatively with the feds for testifying in court for the defendant.
Right. But then
now,
the DA would have to be corrupt and,
Yeah.
Moving on.
Chris Catania says, if I recall, it's unusual that actual district attorney is prosecuting this case. Could that be because he wants to be present so he can cover up his own actions, or am I off the mark? I think you're off the mark in that they assumed, generally, I guess, the DA would prosecute the cases that are either like super, super complicated and require that level of expertise, or they want the slam dunk cases that they can wave their flags around at election time. And I think the DA thought this was going to be a slam dunk case so that he could ride off into the sunset going, woohoo, I got this murderer sentenced to jail. I don't think it's working out that well for him.
Yeah, that is what they said about Binger, that Binger prosecuted Kyle Rittenhouse for political reasons and because he wanted to run for a DA when he was assistant district attorney. It didn't really work out for him in that regard. But
Natalie Wisco Natalie Wisco was saying that he tends to only take cases he's sure he can win. So that's the likelihood of that there.
Well, I'm not sure about this one. I wonder what the jury is thinking. I wonder how people are feeling about this. There's such polarized opinions between our chat and the long crime chat. So I don't know. I wonder how it's going to end up.
Well, I know that I've already decided that they should be not guilty because nothing during the prosecution's case in chief convinced me even remotely. Well, I'll say I can see him being convicted of stalking. There's been plenty of evidence that he may be guilty of stalking within the Wisconsin statute. I can get that. I can see that. I wouldn't have a problem with that. We're still of course not. But as far as murder, I haven't seen anything that even suggests the guy's dead, let alone a murder took place. There's no evidence, and certainly not enough circumstantial evidence, no direct evidence to tie him to this crime. And hiding a corpse is just right at. You have to assume there's a corpse to hide before you can be convicted of hiding a corpse. So I just don't see it. That's where I'm standing, and I've kind of made up my mind here. Unless something hugely dramatic happens during the state's redirect stuff, during their rebuttal phase. What are you thinking, Chandler?
I think we'll see. It's impossible to know what a jury is thinking. But
well, what are you thinking? No, I don't care what the jury's thinking. What are you thinking?
What I'm thinking, I agree with you on almost all of that. I agree with you that there is potential that they could convict on the stalking charges. Looking at the statute, I'm not sure if I personally agree that Sadie knew at the time. So the statute requires knowledge at the time of the alleged stalking and fear of one's life or danger to somebody else that is close to you. I'm not sure that's been substantiated. She did say she was afraid of him. It could be proven, and I think if he's going to be convicted on any of the charges, it will be the stalking charges. I'm not sure if it can be proven in both charges. I maybe for Sadie, but not for Rosario. It's not entirely clear. Murder, no. Hiding a body, no.
Niklas, what are you thinking?
I'm still where I was last week, that maybe stalking, but I don't know the statute. But most of what the state has is what the Sadie or the daughter said. And now continues, they have proved the daughter wrong on the Levi's jeans. And I am assuming they will go into more of a testimony. So that might be interesting. And I'm still not sure the guy is dead. He owed so much people money that it's not impossible that someone went there, gave him a good old beating, and then he skipped. Called mama from a burner phone, stashed everything else, and said, "Mama, I need to run."
And speaking of munch, what are you thinking, Aussie? Oh, shit. Hang on. Everybody's in the hot seat. There we go. No, that's the wrong one too.
It happens to the best of us, Hayden. It happened to me too.
Oh, there we go.
I feel your pain.
Hi, Hayden.
Good morning, everybody.
Good morning.
Sorry for being late. I just jumped over from the XXX trial where we officially had a verdict. So
yep,
I was just following up on that for a minute. Yeah, guilty verdicts across the board. First-degree murder and armed robbery. So sentencing is on April 6th.
Cool.
As for what I'm thinking, I agree with Niklas. I'm not sure the guy's dead. He could be sitting on a beach earning 20%. So as far as I'm concerned, they've got very little evidence, in my own personal opinion. And look, they may have something in the stalking charges. I've yet to see that proven beyond reasonable doubt either, frankly. I mean, there's a lot of wishy-washy stuff in there.
Well, let's go through them. Stalking of Sadie. What do you think? Your personal feeling. Could he be convicted of stalking Sadie?
Could he be convicted of it? Yes, I think he could be. Do I think he should be? No. I think that she's a batshit crazy chick that was a stage 5 clinger. And I think that that's potentially why Rosalio's run.
Stalking Rosalio.
That one I have more issues with. I mean, the photos on the computer, the potential for having broken into the truck, which I still don't think is accurate, but I do think there's been enough bullshit testimony to say that there may be a juror or two that might get in there and they might have a hard head about it and say, well, if you don't want to convict him on murder, then I think we should be convicting him on stalking him for Rosario, because there's enough there. And I'm just like, well.
All right. We got a couple super chats here. Oh, yeah, go ahead. What?
One quick comment. I did find it really interesting that the daughter testified that she saw her father get the registration out of the truck. She's 12 years old.
Mhm.
I mean, wouldn't she? It was like when Amber Heard said, I felt a boot in my back when she was supposedly kicked on the plane. How do you know it was registration? She should have said, if she really saw that, she should have said, then I saw my dad take a piece of paper out of the glove compartment. And then I later looked at it because I'm nosy, and I saw that it was a registration, whatever. But how did she know it was registration? How do you know what? I mean, a registration paper does not look different from, I don't know, literally any other printout that size and shape. I mean, why would you know that at 12 what it looks like? I'm sorry, I just don't buy that. I hope the jury has a problem with that as much as I do, but they might not have picked up on that.
Sure.
Anyway.
Now, super chat. Ryan Akon, if you guys are really having a 2024 meetup and the Americans have to fly all the way across the Pacific, save us some money, increase the vices, and do it in Bangkok. This is just a very early idea that Legal Mindset Andrew and I are having, is like an October 2024 meetup in Korea. People can spend a few days in Busan and a few days in Seoul and doing things that would sort of defeat the whole purpose if we had a come to Korea time and held it in Bangkok, Ryan. That would literally not help it in any way, shape, or form. So yeah, we would not have a meetup in Korea in Bangkok. But it is the very early stages. Who knows what the hell will happen? Here for the Truth says, how does Law and Cuck and Court TV decide which trials will be televised? Whichever ones will let their cameras in.
Yeah, which is interesting because I did just see that there's another bill going through to try and push cameras into the Supreme Court, which would be interesting as well.
Well, and I found out that Law and Crime has a second channel I never knew anything about. Called like Channel B. It's like Law and Crime Channel B or something like that, where they just show like lesser trials with crappier court audio.
Oh, great. Lesser court audio. That's what we need.
Yeah. Strong says, now there's so many things wrong with this. Ozzy, did you record Jeff as dialing in his sleep? First of all, you can't ass dial in your sleep. It had nothing to do with my ass. And I wasn't dialing.
He didn't butt dial.
Yeah.
Just timed a whole bunch of people out.
People were being timed out by my hand or the pillow or something. And it wasn't recorded. It's just what you saw in the chat on the stream Friday. That was, there literally couldn't be anything more incorrect with this statement other than, it's like everything in the statement's wrong. All right.
Oh, so you're saying you were awake?
No, I wasn't ass dialing and,
well, you're saying everything in that statement's wrong.
Oh, okay.
It says
Well,
in your sleep was there. So
yeah,
that's
but it was doing things in the sleep part that's incorrect. Now, if it said Jeff was asleep and did this, that would be different. I'm sticking to my break.
Okay.
Words mean things. All righty. Well, this sort of catches us up with the catching up on the stuff. Oh my God, the court is still out. We need to catch up Ozzy on what's been happening here. And I guess we can do this here, and then we can just kind of send it over to. No, I'm ready to go. We can catch you up here, and then you can take it on over to your place because this is an indefinite delay here.
Oh shit!
This is like a rain delay at a sporting event. Okay. The catching up isn't going to take very long at all. Thank you so much, Corn Pop, for the super sticker. Deeply appreciated. And before we go, I just want to give a special thanks to Hayden, AussieOverlawd, because he's a smart guy. He knows things. He does things. This NVIDIA broadcast is the shit.
I've got to get on that, you guys.
It makes me look good. I've had like several people compliment me on the quality of the camera and broadcast today. So
You too. That background blur just really like it brings everything into focus. It's an excellent quality.
But I must say I'm partial to the I'm kind of partial to the background removal. I like this blackness. I like the hello darkness, my old friend.
Oh, you're just in an abyss, like just in a void in
Yeah,
space.
I kind of like this. But
cool.
anyway, yeah, Aussie gets a special shout out for mentioning this NVIDIA broadcast. Of course, it took like 30 minutes to update all my drivers before I could load it, but hey, we're good. All right, here's what happened today.
Yep.
We had our first witness was a detective who reviewed drone footage and testified for the defense that the drone footage showed nothing. He was a dumpster diver. They went through all the dumpsters and found nothing illegal, nothing in the dumpster. And then on cross-examination, the district attorney Gravely, he elicited testimony that there were no body parts found in the dumpster either. Why he would ask that and confirm that he's got an even worse case than he thought he had, I'm not sure why, but yeah.
Well, it's not like he's made smart decisions throughout this entire process. Let's be completely honest. Gravely's
Doc Ock Rock says if you want to get some sounds filtered, use RTX voice. It filters out anything not human voices. This NVIDIA noise filtering thing is pretty damn awesome too. It's actually a really, really good program. Anywho, no body parts were found.
Did we skip over the witness that is not being included, the landlord?
Yeah, because he's not included. We haven't talked about it. We're talking about the ones that have been included right now. The ones that have been given testimony.
Right.
And the ones who skipped town.
Yeah, then the second detective. Yeah.
I was simply bringing it up. I just thought it was interesting that they wanted to include a witness, the landlord, who apparently was aware that Rosalia was behind on his rent payments. And even though that was sustained and that witness was not allowed in, I think that it adds to this more credible theory that he had reasons to disappear. But it's not part of the case. The jury didn't see it. They didn't observe it. It was just a part of court this morning, so I thought of mentioning it. That's all. Anyway.
And so the second witness they put on the stand was another detective. And he did an on-air unboxing of Zach's clothes. Took his shirt out, said, "Here's his shirt." Took his Levi's out and said, "These are his Levi's," thus proving the daughter wrong in her case that he never wore Levi's ever. And took out his flip-flops. Mercifully didn't take out his underwear and just asked if there were any stains of interest on his underwear. That was exactly my reaction. So the answer mercifully to that question was no.
Court's back.
Is it? Not on my stream.
Just talking.
Is he? It was behind. All right. I was 30 seconds behind.
All right, hang on.
Now let me find out where we are. Start cam.
Who's going to be giving evidence against themselves?
Obliged to say anything at all in this case?
Oh my God.
Testify in any way?
Don't do this, dude.
If you decide that you do not wish to testify, there'll be no mention made of that unless
Don't do it.
you request that it be mentioned or one of your attorneys mentions it. If you decide to remain silent, I will not comment on it. The district attorney will not be permitted to comment on that. And the jury will either be given an instruction that they are to disregard the fact that you decided not to testify and may not consider it in any way in reaching their verdict. If you decide that you do want to testify, then the district attorney will be allowed to question you about anything which is germane to this case. Relevant, pertinent, and that could even extend to matters for which you're not on trial. An example would be if it's relevant to this trial, and I've ruled some of it irrelevant, but if it becomes relevant to the trial, he could ask you questions about marijuana that if they're relevant, pertinent to the case, you'd have to answer and could not take the fifth on those. You can't selectively take the fifth on some matters and not on others. Once you're on the witness stand, once you testify, he can cross-examine as to any matter pertinent to this case. And
Okay.
you will have no right of silence with respect to those. I'm not suggesting that I would permit him to examine you about that. But if, as the evidence develops, he feels it becomes relevant, he can make another shot at trying to let me testify, trying to get you, well, try to get me to admit evidence about that, and then in that event would be allowed to question you about it. So that's one thing. He can ask you also about any criminal record. Is there a criminal record?
Yes.
You can ask about a criminal record. You'll have to clear that with me first. Or any recent act of dishonesty may be something that he'll be permitted to question you about. Do you understand that? Any question about this at all?
Don't do it.
If you decide to testify, you'll have a choice. Either I will say nothing about it at all and district attorney can't comment on it. No, what am I doing? If you decide to testify, the district attorney will be allowed to comment on your testimony. And you'll have the choice whether you want me to say nothing on the subject of your decision to testify, or, no, I'm sorry. It's Monday. If
No,
you
you're
decide
just
to testify, then there will be an instruction given about weighing the testimony, which provides that your testimony should be weighed as the testimony of any other witness. Considerations of interest and other matters bearing upon credibility apply to the defendant with any other, as well as any other witness. Pardon me?
I can't hear you.
Either instruct the jury that just because the defendant is charged in this case, you should not discredit his testimony. That's the language you're talking about. That's optional.
Yes, thank you. I knew I was struggling with it a little bit. So there will be some discussion about your testimony if you decide to testify but it will be along the lines that Mr. Ober has indicated. Do you have any questions about this at all?
I think all the questions I have are now sitting with at least two of my three attorneys. And I would like a little bit more time for them to consider what I've asked of them, but I will be doing whatever they recommend anyway. So largely it's going to be on their advice. And I think they're pretty clear on how.
He has a nice voice.
Okay, well, I'm going to continue the discussion now. And I'm going to rely on them to communicate to me what your final decision is. And you can't change it up to the last minute, but I need to know about it. So if your lawyer says, calls you as a witness, then I will take that as indicating that you have made a final decision one way or the other. If she calls you to testify, meaning that you've made a decision to testify, and give up your right to remain silent. If she tells me that you don't wish to testify, then I will take that as an assertion of your privilege, and that will proceed with the case on that basis. Any question about this?
Well, I understand.
Has anybody threatened you or pressured you or forced you in any way?
In any way regarding my testimony?
Decision about testimony?
No.
Has anybody promised you anything in exchange for this? Is your mind clear today?
I believe so, yeah.
Are you feeling all right?
Good as I can be.
Have you ever been treated for a mental or emotional disorder?
No.
Where were you born?
Fort Washington.
And Port Washington? And do you have any questions at all about your rights here? I have to say I didn't do as well as I could have done in explaining it to you, but just so you understand, it's your decision and no one can force you in any way against your will. And even if you decide to overrule what your attorneys are suggesting, that's your decision entirely, and they have to accept it. And as do I.
Yeah, I think my attorneys gave me an excellent explanation. I do have concerns. I do have questions, but as far as testifying is concerned, I think they were very clear with me about that. And like I said, I would like a few more minutes to talk to them about a concern. I don't know how they're going to address it, but I think we're already basically on the same page. How things are going to go forward.
And you will have a little more time before the occasion arises for you to decide. But at this point, as I indicated, I'm going to assume that you're fully comfortable with whatever questions, maybe not what they ended up telling you, but that you've been fully advised and you've made a decision based upon your own considerations and their advice.
Yep.
Okay.
Yes.
Any other question anybody wants to ask?
No, Judge, not at this time. We're just waiting on, I did send that second stipulation to the clerk, so we're waiting on getting that so we can sign it and we'll be ready to go.
So is our plan then to present the rest of the defense case, including the stipulations, and then for the defense to rest and the state to try to present its witness before lunch?
Yes.
Okay.
But if it gets really late, we'll break for lunch before your witness.
Okay.
Okay. All right. I'm satisfied that Mr. Anderson is acting freely, voluntarily, and intelligently, understands the nature and qualities of his acts, and he needs a little more counseling with his attorneys, he wishes, and then whatever decision he makes, I'm satisfied there is no constitutional impediment. Anything else before we start? I would rather just get that stipulation. What's the sequence?
We were thinking Zellman, last physical witness, then I would
Zellman.
read in the two stipulations, defense would rest, state would call their last rebuttal witness.
I wasn't remembering the name. So let's go with that then.
Wow. So
call
this
the
could
jury
be
then.
with the jury tomorrow. Wow.
That was interesting. I was hoping they would get some expert around the blood, but it seems like they won't have that. Or the DNA evidence.
Yeah, they're going. The sounds like everybody should be all arrested up except for the. Wow, I mean, this is wild. They could be wrapped up by lunchtime. Huh. Well,
Yeah.
wasn't
So
expecting that.
Is the defendant going to take a stand, do you think?
Don't know.
Is
That
that
was very
standard
cryptic.
advisement?
it just, I don't know. I mean, it's very, very risky, but a lot of times they do it. Sometimes it works out. Sometimes it doesn't. I don't know. I didn't get any hints from that at all, whether the defense counsel wanted him and he didn't want to, or whether he wanted to and they didn't want him to, or I don't know.
That's
What
I'm
was your
leaning
guys'
towards.
feeling of all of that?
I'm leaning towards he wants to testify and they're telling him not to.
Well, he did say that he was going to follow all of his attorney's advice and that he would do what they advised him to do. It sounds like there might have been some issues, like perhaps he does want to testify, but he wanted to figure out whether he'd be questioned on certain aspects of, you know, his criminal history or something like that. It's hard to tell, but just as somebody who is new to trial watching and isn't an attorney, I don't really know whether that's standard to advise a defendant in that way, unless there's some indication that they want to testify.
Oh, the judges will always tell them what their rights are like that. You have a right to do this. If you do, this is what happens. If you don't, they can't make any inferences, et cetera, et cetera.
Defense would call Kurt Zellman.
And you women, settle down. You were all like all over his voice there. Jeez, ladies, calm yourselves.
If he testifies, that is a
He did have
good
a
voice.
nice voice. Yeah, he did have a
good
great
voice to testify with.
Well, we haven't heard from him all trial, so this is, you know, it's funny to hear his voice for the first time. He does have a nice voice.
And let's burn through some of these while they're waiting here. Corn Pop sent 2 super stickers. Thank you so much, Corn Pop. Appreciated.
Raise your right hand, please. You solemnly swear the testimony you are about to give in this matter
Are you
will
behind
be the
again?
truth,
witnesses
the whole
on
truth,
stand.
and nothing but the truth, so help you God.
I do, Your Honor.
Please be seated.
Good morning. If you could just state and spell your name for the court reporter, please.
I couldn't hear
It's
you at
Kurt,
all.
K-U-R-T. Last name is Zellman, Z-E-L-L-M-A-N-N.
And what is your title? Is it Mr. Zellman?
I'm the Deputy Fire Chief for the Southern Ozaukee Fire Department.
All right, let's bring it up.
Zellman would be fine.
The
Deputy
fire
Chief
marshal
is
guy.
Okay, great. Thank you.
Fire Marshal Bill.
You just said what your position is with the fire department, but if you can kind of go into what your position entails.
Kind of a jack of all trades. I'm number 2 in charge at the fire department. I oversee both the EMS and the fire inspection prevention bureaus and the training bureaus.
And you were kind of jumping to it. In May of 2020, you were actually called to the home of Mr. Zachariah Anderson.
That is correct.
And you were called to put out a fire that was on the property.
I was called in as support with our fire apparatus to make sure that the fire didn't grow. It was already out when I got there.
The fire was already out?
Yes, ma'am.
Okay. And in this matter, were you ever asked to see if there were any burn permits that were associated with that address of 6813 West Highland Avenue?
Yes, we did receive an information request for burn permits at that property.
And can you kind of explain what burn permits are for in the city of Mequon?
In the city of Mequon, we do allow open burning of only natural materials that originate from the property's residence or the property itself.
And these burn permits, is this something someone has to apply for?
Initially, yes, ma'am. Burn permit is applied for. We go out and inspect the property, make sure that it's suitable to burn, that they are within all the regulations, and then we issue the permit. Renewals are generally, as long as the person doesn't change any of the initial, we don't go back out and re-inspect.
So when you go to inspect, what are some of the things that you look for to pass someone for inspection for the permit?
That there's a containment system for the fire, or rocks or something along those lines, that the size of the burn permit is within the, or that the size of the burn location is within the correct parameters of the permit, and that the setbacks are followed.
And if a permit is generated for an individual in the property, would that mean that they passed the inspection and that the burn pit had been inspected?
That assumption could be made, yes.
Okay. In looking whether the property and Mr. Anderson had permits, were you able to find any information about permits being obtained?
Yes, I was able to locate in our database the years that permits were obtained.
And can you explain the database for the jury? Basically how those records are stored?
It's simply an Excel spreadsheet that we add a tab each year for each year that a permit's issued.
And are those records accurately kept?
Yes.
I'll stipulate the record if he just wants to testify. Foundationally.
Okay, great, thank you.
Yep.
I'm gonna hand you what's been marked. Well, before that, do you remember the years that Mr. Anderson had burn permits for his location at 6813 West Highland?
I'm sorry, I don't remember off the top of my head, no.
Okay, I'm gonna show you what's been marked as Defense Exhibit 359.
You're muted, Jeff.
Jeff, you're muted.
This is Defense Exhibit 359.
Damn it.
Can you explain what that is?
This is the form letter that each time a burn permit is issued is provided to the person requesting the permit.
And what year is this permit for?
2018.
And was there a time where you changed your database so that records previous to 2018 would not be accessible as far as printing out the permit records?
Yes, the database itself only goes back a few years. Before that, it was essentially a handwritten operation prior to my employment there. So I don't know exactly what year the database converted to electronic.
Okay, and that 2018 burning permit, when did it expire?
All burn permits in Mequon expire December 31st of the year of issuance.
And then for the 2018 burning permit, what was the address of the burn site?
This permit is issued to 6813 West Highland Road in Mequon.
And the resident?
Mr. Zachariah Anderson.
Okay, and did it have a note of where the burn pit would be?
Yes, it's noted as south of the house.
Okay. I'd ask that Defense Exhibit 359 be introduced or received.
Received.
Handing what's been marked as Defense Exhibit 360 to the witness. Can you explain what that is?
This is a burn permit for the year 2020 at the same residence.
Same residence, and is it the same resident?
Yes,
And that would be Mr. Anderson.
yes.
And the note as to where the burn pit would be for 2020, was it the same as well? That was south of the house.
Yes,
And that burning permit would have expired on December 31st, 2020.
correct.
So I'm going to ask that Defense Exhibit 360 be received.
No objection.
Received.
So can any resident of Mequon apply for a burning permit?
Yes,
And is that something that residents of that town have to do if they want to have fires on their property?
that is correct.
And to your knowledge, do a lot of people in the Mequon area get burn permits?
Objection, that's a no.
Overruled.
Sorry, you can answer.
Except that What's a lot?
Do you know the number of permits approximately that are issued every year?
I'm sorry, I don't, because our secretary is the one who does the issuance, so she keeps count. I don't.
In your work there as deputy chief in the city of Mequon for the fire department, have you seen people do burns on their property in the city of Mequon?
Yes,
And if they were to do that, they would have to have a permit.
that is correct.
I have no further questions, subject to redirect.
Assistant Chief Zellman, does the burn pit permit an individual to burn a bleach bottle or any container of bleach in their burn site?
No, sir, that would be not permissible.
Okay, and what about clothes that have metal buttons on them? Would that be a permitted item to burn in any burn site that these permits involve?
No, sir.
What about steel-toed boots? Are those legal to burn in these burn pits?
No, sir.
And what about underwear and socks? Are those items legal to burn?
No, sir.
Okay, so those are not covered by the burn pit that you've been.
I will
shown
send
as
him to jail for the rest of his life. He burned some socks.
I have nothing else, Judge.
There were metal buttons in the fire. He's guilty of
experience
murder.
of seeing people's burn pits and what they throw in it if you have to put it out, is it common that in areas such as Mequon, people will burn some of their trash?
If they are doing so, it's in violation. I have gone
Oh,
to
yeah.
reports
Yes,
of
isn't common.
items being improperly burned. Yes, so I have seen other people improperly burn items in the city of Mequon.
No further questions.
Do you recall the date of this incident? In other words, the time period of around May 19th, 2020, May 20th, 2020?
Are you asking about the
Do you
time I was on?
recall, you recall going to this scene?
Yes.
Okay, I mean,
Yes.
you have your own independent memory.
Yes.
Okay. Had there been heavy rains the days before that?
Yes.
And you found that there was still a fire that required some intervention by you to allow people to go through it. Is that correct?
That is correct.
Even though it had been a heavy rainstorm.
Correct.
Nothing else.
I don't have anything else for Deputy Chief Zellman.
You may
Thank
step
you.
down, sir.
Okay.
Yeah, with burn permits, we do have those over here in Sweden as well. And of course, I would never do it, but I have heard on occasions that trash will be burned as
As
well.
far as it relates,
Two stipulations. Because there was two witnesses that couldn't show up today. One was a prosecution witness that was being recalled for a prior inconsistent statement, but mysteriously suddenly went out of state.
2020, Officer Kyle Morrissey of the Kenosha Police Department obtained video footage from Casey's General Store, 280 Highland Drive, Fredonia, Wisconsin, and Ozaki High School, 401 Highland Drive, Fredonia, Wisconsin. The video footage was later reviewed and nothing of evidentiary value was located. This is signed by Attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 361 be received.
And is that agreed?
It is.
And as I indicated earlier, in the trial, several weeks ago, when something's stipulated, that's agreed by both parties as being accurate, and no further proof will be received on that subject to either bolster it or to question it. Any question about that? Okay, thank you.
The defense is going to read the second stipulation, which is marked as Defense Exhibit 364. It reads, the following are statements attributed to Detective Lauren Anschutz of the Kenosha Police Department, who is an unavailable witness in this matter at this time. The parties have stipulated that these statements should be read in their entirety to the jury in place of testimony that Detective Anschutz would have made if he had been available. On May 19th, 2020, Detective Anschutz interviewed OA. During that interview, OA told him the following. Her brother was playing with Legos in the basement of her father's home because he likes it down there. She went down there to check on him. OA told Detective Anschutz that she never saw the unregistered gun and that she never saw any guns here in Wisconsin.
Yes.
In Detective Anschutz's report, he reported that during a phone conversation with OA on May 22nd, 2020, OA stated the following. Mr. Anderson never took the chainsaw out of the back of the van. In Detective Anschutz's report, he reported that on November 6th, 2020, OA stated the following. Mr. Anderson brought a chainsaw on the way up to the tree farm. When they went to the tree farm, Mr. Anderson and her uncle were fixing the chainsaw. When they left the tree farm, Mr. Anderson took a different chainsaw home. Once they arrived at the tree farm, Mr. Anderson borrowed Grandpa's work boots and took off Grandpa's boots and placed them in the van and took them home. She believed Mr. Anderson had a storage unit. Mr. Anderson told her he had to leave to go to the storage unit one day and returned 10 minutes later. That's a stipulation that's signed by attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 364 be received.
Stipulated?
That is stipulated, and we have no objection to the exhibit.
All right, they'll be received and are stipulated too.
So lying under oath is bad.
Yeah, even if you're 14, still quite bad.
Yeah, I had that argument with someone over whether or not 14 was old enough to know the difference between right and wrong, and the age of responsibility and whatnot. And
the defense just rested.
Mr. Rivley?
Well, there you go.
The state has one well witness, and that is Officer Quintana.
And while he's doing this, Hayden, you said you were stream sniping me. What you can do is when you came into, if you like bounce out and then come back into chat, there should be a little pop-up thing that says stream this to your audience.
Yeah, but I think that would mean that I have to kill my current stream. I looked at that when I came in.
Ah, okay. Maybe it does. I just don't know. No one's ever used it before. All right, we've got the last little quick witness here, and then we'll be heading on over to AussieOverlawd. Yeah.
You solemnly swear the
we
testimony
go.
you're about to give in this matter with the truth, the whole truth, and nothing but the truth, so help me God.
Yes.
Please be.
God forbid we
You are.
hear something truthful in this case.
Can you please state your first and your last name and spell both your names for the record?
Eric Quintana, ERICK-QUINTANA.
And Officer Quintana, where are you employed?
Kenosha County Detention Center,
And what's your position there?
Direct Supervision Officer.
And so, Officer, how long have you been employed at the detention center?
It'll be 5 years next month.
So I want to ask you about a particular area of the detention center called H West. Can you briefly describe what H West is?
Oh my God. Does it really matter where they were situated in there?
For discipline for X amount of days.
No.
And how many, do we call them cells in that area?
Yes.
How many cells does that unit have?
22.
22. And how are they tiered? Are they all on one level or are they on two separate levels?
1 through 10 is on the bottom, 11 through 22 is on the top.
And when an individual is in H West, and I'm speaking now about back in the time period of February of 2022. So if things have changed, please alert us to that. Okay. In February of 22, what was the arrangement for an individual who was assigned to H West. So how long would they be in their cell versus in other locations?
Usually sometimes like there'll be a malfunction and we'll have to move them from a different cell. That's the only time they're moved.
Okay. And so how many hours a day are they in their actual cell?
23.
And then for that last hour then, unaccounted for by in the 24, what is happening to an inmate who is in H West?
It is their rec area. They're allowed to be in the day room where there are lines they cannot cross. They have to stay in a specific area.
And where are the officers, meaning jail staff, who would then monitor compliance with that? Where are those individuals located?
It's the officer station. We call it the bubble, and it's looking into the H West day room.
So, and I assume it has a vantage point where all of the cells are visible?
Yes.
And how many officers would be assigned to monitor H West at any given time?
2 officers.
2 officers? And are they both located in what you call the bubble typically?
Yeah.
All right. So I'm going to ask you to just orient me through a couple of pictures. And first of all, was a request made that you take a couple of pictures from the vantage point of particular cells? Was that what you were asked to do?
Yes, my supervisor instructed me to take 2 pictures from each vantage point.
Okay. And what did you utilize? What piece of machinery or equipment did you use to be able to take those pictures?
We have a body camera right here, and we're allowed to take pictures.
You're being asked to speak into the microphone a little more directly. You have a soft voice, and this is a hard room to hear in. Okay, so if you could speak up. So again, answer my question.
We have a body cam.
Okay.
And it allows us to take pictures when we change the options.
And did you do that upon our request?
Yes.
Okay. So I'm first going to have put up on the display up there what's been marked as State's Exhibit. Is it 362?
362.
362, officer. My first question is, did you take this picture once you see it?
Yes.
Did you take that picture?
Yes.
Okay. So what cell are you directly in front of and facing out from when you took this picture?
To my back, it's H West 9, and I'm looking at the H West 20.
So if a person was assigned in H West 9, this would be what they looked out and saw from the very front of their cell?
Yes.
Okay. And is this picture, which is 362, is that a true and accurate copy of the vantage point from cell 9?
Yes.
Is there any changes or alterations from what you know to be the vantage point from cell 9 that in this picture, other than the sticker being on there? Otherwise, is it a true and accurate copy of what you see when you look out of 9 today and back in February of 2022?
That is what you would see. That's what I would see, but the inmate would be behind mesh.
So his visibility would be even more compromised?
Yes.
Okay. But if you're right at the doorway and out of the doorway, this is what you see?
Yes.
Judge, I move admission of Exhibit 362 based on the testimony thus far.
No.
So from this picture, are you able to orient us as to where cell number 20 is?
Cell 20 would be right over here.
Okay, so it's on the separate tier, correct?
Yes.
And it is that essentially as far across as this particular dorm or jail area takes you? It's on the far other end?
Yes, the opposite side.
Okay. And it's upstairs at that location, is that right?
Yes.
So for 23 hours a day, an individual in cell 9 would only see the individual in 20 in the vantage point you've just shown me. Is that correct?
Yes.
Okay. So what if a person was moved to cell 11? Is 11 visible in this picture? And if it's not, then just please tell me.
It is not visible.
Is 11 the neighboring cell to 9, so it would be right next to it?
No, it would be above.
Okay. So 11 is, I see like a ceiling on this. You see what I'm talking about?
Yes.
Okay. Is it above the ceiling?
Yeah.
Is it directly above 9, or is it directly above the neighboring one, which I assume would be 10?
It would be the neighboring one above.
Okay. So it's directly above the neighboring cell.
Yes.
All right. And then if one was in 22, where is that located?
22 is going to be way at the end, right about there.
So that would even be slightly farther than 20?
Yes.
What would be the distance between cell 9 and cell 20 during those 23 hours a day? How far away would you estimate those two are in distance?
I would say approximately 50 to 60 feet.
50 to 60 feet. Okay. And is this a area of the detention center that you have worked in often in your career?
Yes.
Describe the ability of someone from 9 to communicate to 20 or 22. What tone of voice would you have to use in a normal situation to be able to get the people in 20 and 22 to be able to have a conversation with you?
You have to talk pretty loud. Basically, you'd be yelling because there's on opposite sides of the room and there's a lot of echo.
And what, if anything, can you say about whether that yelling would be something that other cells would hear? I mean, in other words, is there some kind of ability to yell in a targeted way, or would other cells also hear it if you yelled, again, from 9 to 20?
No, all the cells will be able to hear.
So if I were to simply whisper or speak in a very conversational voice, I had something confidential I wanted to say from 9, based on your experience in this area, would 20 or 22 be able to hear me?
On a whisper, no. You just have to talk a little bit louder than normal just for them to hear you from 20 to 22.
Okay. From 9 to 20 or 22?
Oh, you'd have to talk loud.
Okay.
You're not going to whisper that.
Okay. So only if 20 and 22, which are close by cells, correct? Correct?
Yes, correct.
Okay. In this, there is, it looks like there's a red line. You see the line I'm talking about?
Yeah.
Can you just point out where that red line is for the jury? So just draw where that red line is so that they know what we're talking about. And does it go on both sides of the stairway there, that as depicted in this picture?
Yeah, it cuts off the stairs and it cuts off part of the day room on the other side.
Okay. And what does that red line mean in the context of the rules or life in H West?
When you're on discipline, you're not allowed to cross those red lines for any reason.
And are people on discipline? Is that, if you're on H West, are you on discipline automatically?
Yes, most of the time.
Okay. So are there ever times when a person who's housed in H West can go closer to that than that red line in the 1 hour a day that they're out?
The closest you'd be able to get without crossing it would be here and here.
Okay. And that's only for 1 hour a day at maximum?
Yes.
Now, if you're in the upstairs tier, are you allowed to walk into the downstairs tier during your 1 hour?
Yes, everyone's allowed to walk in that red area.
And if you cross that red line, then what happens?
One of two things. One, you get a warning. If you do it again, your recreation's over. Or you can just tell them it's over right then and there.
And does that come from the two people up in the bubble?
Comes from one or the other.
Okay. And is this something that you believe is regularly and consistently enforced?
I enforce it, yes.
Okay. I'm going to show you now what's been marked as State's Exhibit 363. And just let me know what this is in relation to this case. So what is Exhibit 363? First of all, is this a picture you took?
Yes.
Is it, again, a true and accurate vantage point from the place you were situated when you took this picture?
Yes.
Does it accurately reflect the distances from one end of this cell block to the other and where the cells are that are in question in this case?
Yes, it is accurate.
Do you think it's changed or altered in any way other than the sticker that's on there?
No.
Again, I move admission of 363 based on the testimony, Your Honor.
Objection?
No.
So from 363, what is our vantage point?
I'm standing in front of H West 20, looking at H West 9.
Okay. I think we lost you in the microphone. So one more time.
I'm standing in front of H West 20, looking at H West 9.
So where is H West 9 on this photo? So the jury knows where a person who's in 9 is located.
Right about here.
Under the stairwell? And on the back, towards the back wall?
Yes, in that corner.
So it's the far corner under the stairwell?
Yes.
Are there occasions where two inmates are ever out for rec time at the same time, or is that something that is forbidden?
No, that is not allowed.
Okay. Well, riveting testimony here.
Where is 22 on this, if you can see it, where's 22 on this particular exhibit?
You won't be able to see it. It's 2 cells this way, like to the left.
And the red line that we're depicting here, is that same red line we saw in the other picture?
Yes, it is the same red line.
Just a different vantage point?
Yes.
Okay. I have no further questions.
Thank you, Judge. I'm going to keep 363 up. The state had asked you that this is the vantage point from cell 20, correct?
Yes.
And again, that's from outside the cell, not inside,
Correct.
because the view from inside would be obstructed.
Yes.
So if the state had asked you about the noise and stuff like that, and you're familiar with working in H block, right?
Yes, I'm familiar.
And it can get, you said, echoey.
Yes.
And so if someone says something and it is not a whisper, chances are other people in the unit are going to be able to hear it.
Yes, correct.
And so if you're in a cell and you hear something coming from a different cell, it might be difficult to pinpoint exactly what cell it's coming from.
Yes, correct.
It's only potentially that you can know who it's coming from based on your experience by sound of the voice, if they're saying who it is, those type of identifying factors.
Yes.
And so coming here then from the picture we see, can you see cell 11 in this picture?
Yes, I can see cell 11.
And can you point out to the jury where cell 11 is?
Right here.
Okay, and then where is cell 9?
9 would right there.
So these are relatively close to each other, just on opposite tiers.
Yes.
So before the state had asked you that if you're whispering or talking quieter from cell 9, would it be difficult to hear in cell 20? You gave an answer. But as far as with cell 11 and cell 9, individuals would be able to speak quieter and maybe be heard just by those cells.
You'd have to talk a little louder, not as loud as 9 and 20, but you still have to talk fairly loud because they're on opposite tiers.
But not, you don't need to yell.
Correct.
How often did you work in H West?
I was pretty often on it on night shift when I used to work it.
A night shift?
Yeah.
Okay. And the state had asked you about the rules about rec and staying inside the red lines. There are times where individuals housed in H West do go outside those lines.
Yes.
And some deputies and correctional officers, some of them might not say anything.
Some give them a warning.
A warning, but they're not gonna, some don't enforce it as heavy as others, correct?
Yes.
That'd be a fair sentiment.
Yes.
So there are times where other inmates do go up to the cell doors of the others
Yes.
and they talk to one another.
Yes.
And this would be during the rec time?
Yes, it would be during rec time.
Okay. people get transferred in H West, do you have to update the records?
Yes, we do.
And so if someone gets switched in between shifts, it would be the next individual that has to update the change?
No, it's the officer who made the switch updates it.
Okay, and do you update that immediately or at the end of your shift?
I updated immediately.
Okay. And you also had talked about how you had a request made to take these photographs.
Yes.
When did you receive that request?
It was on Thursday before my weekend off. Supervisor called and then instructed me to take pictures, and I did with my body cam.
Okay, just this last Thursday.
Yes.
Nothing further.
Questions?
Okay.
So during rec time, is a person who is residing on the first floor
Oh, shut up, Gravely.
able to go onto the second tier ever?
No, they're not allowed to do that.
So that's never permitted.
No.
And if and did I hear you correctly that based on the mesh and the obstruction and the echoes and so forth that you believe that it is
So is someone on the
difficult
second
to
floor
tell
allowed to
which
come down
cell
into the
is communicating
comments?
with another cell? In other words,
Oh, he
if
didn't
you're in a
ask that
cell, you might
question,
not
did he?
know which other cell is talking to you?
Yes.
Nothing else.
I have nothing further, Judge.
You may sit down, sir.
Your Honor, the state has no further rebuttal at this time.
The defense has no rebuttal witnesses, Judge.
Right. Let's take a break at this time, and I'm going to ask that you return at 2 o'clock.
Wow.
Please don't discuss the case with anyone, not even another juror. Rewatch your lesson when you come to the trial. Any questions? Thank you.
Wow. We're done, it looks like. Huh.
Well, there we go.
Well, let me quickly burn through these super chats here, and then we'll figure out what's going on. Elise Lane says, if he was to testify, can they still ask for a Mr. We already read that one. You got kind of like 1.5 there. With 2 witnesses before lunch, it doesn't seem like he's testifying. It does not seem that way now, does it? DA would spend 4 days on him. D, what's his Jeff simping over Winona? What are you talking about, D? What? I have no idea what that's talking about. Russell, why do you think defense counsel did not bring in someone to testify about minute blood found in the defendant's van? Because I thought they just trashed them. I thought they did a pretty good job of destroying them on their cross-examination. I don't think it was necessary.
I could have done a much better job than I did. And it's important enough that I think it needs to be recovered. So that you understand your options are that you can testify in the case if you want to. If you do decide to testify, then the district attorney would be allowed to cross-examine you, question you about anything which is pertinent to the case, which could involve matters for which you are not on trial, and you'd have to answer those questions. He would also be allowed to question you about any matter, recent event, which would be suggestive of dishonest behavior, and you'd have to answer those questions, even though they don't directly relate to what is on for trial here. And he could question you about criminal history, and he'd be limited to asking you if you've been convicted of crime before and how many times. If you correctly answer those questions, that would be the end of it. If you did not correctly answer those questions, then he would be allowed to go through, identify specific crimes, dates and places of conviction. Any question about any of that?
No.
Okay. If you decide you do not wish to testify, then there'll be no cross-examination. You won't be questioned about anything about this case. And you would have the option for me to instruct the jury that your silence must not be considered in any way. Defendant in a criminal case has an absolute constitutional right not to testify, and his silence must not be considered as evidence against him in any way, or be considered in any way by the jury in deliberating on their verdict. Do you understand that?
Yes.
I would give that instruction only if you requested it. If you did not request that instruction, then I would not mention anything about your decision not to testify in the case. You understand that?
Yes.
The district attorney would not be allowed to comment at all upon your silence if you decided you did not wish to testify. Do you understand that?
Yes.
Any questions about this at all?
No,
Have you had enough time to discuss this matter with your lawyers?
I believe so.
Here we
And,
go. Last
have
chance.
Any questions that you have been answered to the best of their ability and your satisfaction?
I believe so.
Okay. Any question anybody wants further asked?
Judge, I would just say that we, as a team, have talked to Mr. Anderson about all the pros and cons, just like the court laid out. And so his decision is fully informed and knowing that it's held.
Okay. Anything that you had to comment?
No.
Okay. Then what's the plan when the jury returns?
So will the judge want to have a short instruction conference with us?
I propose, I hope.
So he's not going to testify.
To
Good.
send you electronically proposed instruction draft number 1. I hope so. I hope you have within about a half an hour, so you have some time to review it, and then we will discuss it when the jury when we return. Given what you've already sent me, I don't think it'll be too lengthy. And anything else?
Well, I think that the parties just want to know what the court is contemplating for this afternoon. And so is the court hoping to instruct but have us argue first thing in the morning, or is the court still hoping to argue this afternoon? What is the court's preference?
I think it.
We'd be back.
I think it's unrealistic to try to complete everything today, and I don't want to break the arguments up. So, yes, I will instruct this afternoon, and then we'll start with argument in the morning.
Yeah, that's fine with the state.
And I won't put a time limit on you, other than when I was a young man, I used to. We lived across the street from Kenneth Grube, who was an eminent federal judge in Milwaukee for many, many years. And I would shovel his snow.
Judge.
And,
the
only
fuck?
advice he ever gave me, even though he knew I was in
Just
law
going off
school,
a random tangent?
was I think he probably said stick to shoveling the snow, but he said the brain cannot absorb what the seat cannot endure. So I think that was wonderful advice from him, and I'll repeat it to you. So
And Judge.
and I do need to leave here at high noon tomorrow.
Yep. Understood.
I need tomorrow, that's fine.
2
And
hours.
then, just because you're going to be drafting up those jury instructions, the defense would be seeking instruction 315,
Yes, okay,
just so you know to include that.
sure. Yeah, you should have them within,
Do you want us back here physically at 2 as well?
at 2:00, yes, be back. And I did not ultimately, I didn't want to give 2 separate instructions on counts 1 and 2,
Okay.
but
You'll give the more verbose one for both of them?
I am giving the standard, but I'm going to omit the paragraphs you've deleted from both.
Okay, perfect. Will you bring it to the cart?
So you were able to open up the document, is that correct? You were able to open up the document?
Yes, thank you.
Just
Yes,
wanted to make sure.
yes, thank you very much.
All righty then.
So what now?
Wow. Well, first thing is to clear off these last 4 super chats. And then wrap it up and head us over to Aussie land for jury instructions. Wow, that was surprising.
Kind of anticlimactic, I think.
All right, let me just burn through these here real quick. Nicola Maxwell, Zach Bonesteel, love his voice, not guilty. As nice a voice as he has, that's not how we're deciding guilt or not guilt by the sound of their voice. There's Lon Cuck has a page for people like you. Just kidding. Van Ray lol. Nice to know that the jail looks like my U.S. high school. And official Rogue Ant. So we just gonna let the DA off the hook? Yeah, probably. And there's a couple other that that are just too far back for me to scroll back to and highlight. But Mangs, thank you so much for your $10 super chat. Said, so was Gravely just trying to prove Snitch 2 was lying due to location? I've heard inmates can communicate by draining toilet water and sending notes through the drain. Ish. Yeah, that's there is that. And I think that is it for the super chats. All right. Phew. Are you ready for the handoff, Ozzy?
Yeah, that's fine. I'll head across and I'll see you all soon.
Be there in about 30 seconds to 1 minute.
All right, see you there.
All right, what we've got to do is head on over. Wah, says Vince Clortho. It's probably the best comment of the day right there. All right, we need to set this up so we can redirect directly over to AussieOverlawd here. Customize that thing. Redirect. Add. AussieOverlawd. There we go. AussieOverlawd is added. And boom. All right, so what's going to happen here is I'm going to give everybody a big thank you. Maybe Ozzy will be a nice human being and actually send us the link so that we can join him, unless he doesn't want us to because he hates us. But anywho, we've got 2,200 people still here. We're going to wrap this up real quick. The first thing I wanted to say is just my last plea for everyone who has not subscribed to please reach down there and hit that subscribe button and subscribe to my channel. Currently, we are, last I checked, let me double check here to be sure. We are exactly 125 subscribers away from 36,000.
Oh, come
So
on, people.
anybody
You can do
that-
better. Do it.
Any of you that haven't subscribed, any of you that haven't subscribed and have been here for a few seconds, this is what we do. We do trials, we do other issues, we do, all kinds of things. Maritime related stuff, we do pop culture stuff, we talk about important issues and whatnot, and we do trials. So please do me that big favor. I would appreciate it. Since we're missing a Nicola Maxwell. No, we did. Corn Pope, you said missing a super chat from Nicola Maxwell. I doubt it. I don't know what you're talking about. There, we just did one. So I'm not sure if you just didn't hear it. Nicola, the only one I have from you is the one that we just read. So I'm not sure if there's a G4 Outdoor. I missed your super chat. Thank you for that. That is correct. Okay, said G4 Outdoor said a long time ago, like an hour ago, why is it being passed over to the DA? Not only mouth die, 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 but it was actually the whole sentence mouth. He said die, die, die. I don't think he said the he said part because he finished his sentence saying, what did he say? to you, and then he immediately started mouthing die, die, die. I don't recall him saying he said die, die, die. I don't remember him mouthing that part.
I don't remember that either.
No.
But the court has the video, so it's up to
Yeah, people
their
said he.
discretion.
People said he sure did. Again, I didn't hear it. None of us heard. We'll have to go back and maybe watch that over on Aussie's time during lunch. All right, Nicola, you missed it, but we'll read it again just to make you happy. I was just joking about you. You didn't hear any of that. Me talking about I said Zach Bonesteel loved his voice, not guilty, and then I said, now Nicola, that's not how we decide whether someone's guilty or innocent. They have a page for people like you over on Law and Cuck. Said, just kidding, we love you. So there you go. There's a full repeat of everything that was said when I read your super chat. All right, everybody, thank you for being here again. Please, that's just my one big pledge today. My one big push, my one big beg is to hit that subscribe button and become a permanent member of the Vice Squad here. Hit the like button on your way out. Wrapping up the like and subscribe poll. How did we turn out today? We turned out today by, did you hit the like and subscribe button? 18% of you said, oops, I did. Now that you mentioned it. 38% of you in the number one slot said yes. And tied in for second and third place at 22% each. Yes, let's get to 36,000 subs. And yes, like Schroeder has, it hits the orange because he likes his oranges. And there we go. On over to AussieOverlawd, everybody. Thank you for being here. Thank you, mods. Thank you, guests. Thank you, all the generosity from the super chatters. Thank you for people participating in chat. And thank you for all the new subscribers. Keep it coming. We'll see you all. We're going to be automatically sent over to AussieOverlawd right now. If that doesn't work, there's going to be a little box right up at the top of the chat that says, hey, something's happening over on Aussie. Go check over there and click on that, and it should take you over there. If that doesn't work, just search for AussieOverlawd and do it manually. Once I hit this end broadcast, it's out of my hands. We'll see you tomorrow for closing arguments. Wow. Everybody, go over to Niklas Starow of Union Rep Labor Law's channel. Subscribe to his channel. Put his videos on and let him just run in the background so he gets his viewing hours up. And also, same name, Starow of Niklas over on Twitter. And speaking of Twitter, we have Chandler Remington with Remy, REMY_ legal over on Twitter. And then over here on the brand spanking new YouTube channel, Chandler Remington. Go there, subscribe, and wait for the first introduction video to come down the pike
this week.
All right. Any last words, folks, before we take off?
Thanks so much for having us.
See you all tomorrow. Nicholas, are you there?
Boomer moment, as usual.
All right.
Great chat, as always. I'm having a lot of fun just reading the chat. Yeah.
All right. Like and subscribe to everybody, and we are out. Talk to you tomorrow for closing arguments. Bye now.
All right, bye, everybody. See you tomorrow.